Welcome to those who are joining. Just gonna, as you probably are well aware, those of you who are in here on a regular basis, you know that I'm going to chill for about 8 more minutes. We'll get started officially at the top of the hour. This is a huge show. I hope you and your wife are good. Yes, we are good. Rhonda's about to join us. So she should be on here shortly. She's just getting some things wrapped up in the next room. We should be simultaneously streaming. Hey, Kimberly. You hopefully you are also watching, Kimberly, the YouTube stream. You've got some moderator privileges over there just in case. I don't suspect YouTube's going to be big. We still haven't gotten a real good following over there. But I have a very I have a lot to talk about. So this may end up being my first 3-hour show. Usually I do about an hour to an hour and a half. However, I had already prepped an hour to an hour and a half worth of work, and then Karen Agnifilo filed a huge motion, 33-pager, that I can talk an easy hour and a half on as well. So, yeah, thank you so much. And Rhonda will be getting in here shortly, so we'll just kind of chill for another 7 minutes. Again, to clarify for those who are joining us right now, we are simultaneously broadcasting on YouTube and TikTok. YouTube is where you want to follow if you want to see the documents that I'm going to be referring to. I'm going to have a lot of things. Boy, my hat's dirty, isn't it? I'm going to be referring to a lot of documents tonight, a lot of websites. I'm going to have highlights on the screen. So if you want to follow those, you do want to check out the YouTube stream. In addition, keep in mind that there is a delay on both YouTube and TikTok, so it gets weird for us sitting in the same room, Rhonda and I, because we have to kind of mute the streams because they're behind. And YouTube lags even further behind than TikTok. So what I recommend you do if you're going to watch both streams, because it's good for me if you watch both streams, because then I get watch time on TikTok and on YouTube. That's just a selfish plug for myself. But if you do that, that's great, but you're going to want to mute one. I recommend that you mute TikTok if you're going to be on YouTube, because YouTube then will stay live and you'll get the audio live with the images that I'm showing live, and you won't have any confusion about me talking about things on TikTok that I haven't shown yet, and vice versa because of delays. Thanks for all the likes and the hearts to get started. That's a great start. I'm also fascinated to see that we're at 27 viewers and we still have a good 6 minutes to go. So it's a good start in the room, all things considered. If you want to smash the like button, the little hearts, that's great for us. Just tap the screen a bunch of times. That helps out with other people getting notified that something's going on. This is a huge night. Again, I had probably an hour and a half worth of stuff to review. I plan on doing that. And then, of course, Karen Agnifilo dropped a bombshell motion today that it is so...
You're already betting on me sneezing.
Oh my gosh, $10 if he's having to sneeze. Oh my gosh. Yeah, it's a thing. It's a thing. Anyways, so it's going to be a big show. And I'll explain a little bit how the format's going to happen tonight. For those of you who can't stay late because you're in different time zones or you're on the East Coast and it's already going to be starting late for you, let me tell you this. This is streamed on YouTube. It's recorded on YouTube. Also, I believe if you follow my account, you should be able to replay. I got some kind of yellow tint in this light with these glasses. I got polarized glasses. I need to go with something else that doesn't put yellow on my eye. But anyways, the point being that it will be recorded and it's going to be a really long show. I expect altogether there may be 3 hours of show tonight, of which an hour to an hour and a half of it's going to be on TikTok and YouTube. And then about the last hour to hour and a half will be YouTube exclusive, because there are some things I absolutely cannot talk about in detail on TikTok based on their community guidelines. So we will be respectful to YouTube or TikTok and their community guidelines, which means that we won't be able to cover the big topic that you want to hear the most in much detail. And by that I mean you probably want to hear, on my opinion, on Karen Agnifilo's bombshell motion that she filed today. I will have to be very brief with that discussion at the beginning of this show, because to even read Karen's wording in her own writing would get me kicked off of TikTok. It is that brutal. It is that controversial that to read her own words would get us kicked off of TikTok. So we're going to go ahead and respect TikTok's desire to have us not talk about that case in that level, because those words will be auto-filtered by a bot, which will then shut the live off and it'll be over for all of us. So I can't tell you exactly word for word what Karen said, but I do believe that I can get away with it on YouTube. So if you want to see my analysis of that document where I will read word for word what Karen said, you're going to have to do that at the end of this show when we go to the section I will call Too Hot for TikTok, because TikTok doesn't want us to talk about that. That'll violate all kinds of terms of service for us to be able to even talk frankly about what she stated in her motion today. So again, 3 more minutes. We'll give it a bit of time. 3 more minutes, and then we will get into the official, what I call the monologue. That's going to be me talking about what the agenda is for tonight, how it's going to go. That usually takes me 7 minutes to get through, and then we will get right into the agenda and point by point. I'm going to tell you how it's going to be laid out. I'm going to explain that in detail. Again, up here on the screen on TikTok, you can see Devil's Advocates 2024. That's our channel on YouTube. Again, if you want to follow along with the documents that I'm showing, you want to make sure that you're tuned into a browser to watch it on YouTube.
Hi, my foe.
And again, for my benefit, it would be great if you streamed it in both places. However, if you've got it on your phone and that's the only place you got it, I do probably recommend you watch it on YouTube if you want to follow along with the documents. I haven't gotten to the point where I can really do documents well on TikTok. Maybe it's something I can improve in the future, but for the time being, I'm going to read things to you straight from the websites. So if you want to know what the websites are, you may have to go to TikTok or to YouTube to see the URLs. But if you just want to hear me tell you what it was from and the source that it's from and the basic title, you can probably go find it on your own. So you're not going to miss really that much on TikTok. Other than that, just at the end part where we're going to do the whole Too Hot for TikTok part, and you're going to need to be watching the YouTube stream to hear that part. Thanks again for coming tonight. Give us a couple minutes. We're going to get settled in. Let's do a sound check on Rhonda. Do you have your mics on?
I'm a little confused about which one's which.
So as you were facing your chair, the one on the left was YouTube.
Okay.
And the one on the right was TikTok.
Okay, so this should be YouTube. And this should be TikTok.
Okay. And you can put them both up by your mouth and just, just one will go one and one will go the other way. That's the theory at least. So Kimberly can hear us probably on TikTok. Have you heard us on YouTube as well? Sound check for YouTube. About 1 minute, by the way, just 1 minute, and then we'll get started.
So Eve Lee asked, is it in the site with his other stuff? I'm not sure what they meant. So I asked them, but...
Is it in the site with my other stuff?
Yeah.
Is that what the question was?
Yeah.
So I have a website, devilsadvocates.info, if that's what you're talking about. And then it's on YouTube. So you can hear both of us, by the way, Kimberly, both Rhonda and I on YouTube.
She said yes on YouTube, so.
Yeah, she said that before I asked the clarifying question,
okay.
but yeah. Okay.
Yay!
Sound check is good. All right, it's 6 o'clock. So I hope I answered that person's questions. So as a disclaimer, let me start with this. Everything that you're going to hear tonight is from publicly available information, and it's for educational and entertainment purposes only. I am not an authority. I'm not news.
Stuff.
What's that?
I said the legal stuff.
The legal stuff, right. I'm not news. I'm not an authority. Nothing that I say tonight should be taken as a fact unless it's backed by court records. And I'm going to show you the court records. I'm going to show you the parties and remind you that all parties are presumed innocent until proven guilty in a court of law. And that goes both ways. Like when I talk about the prosecution side, we're also giving presumption of innocence on their part. So we're not accusing everybody of horrible things. Everyone has the presumption of innocence until proven guilty in a court of law. Now, I will let you know, I believe that we're going to have, some of you know that we've had Cynthia Thornton on my show before, an attorney from New York and Texas. She's going to be, I think, in here somewhere tonight, if she's not already here. She's going to be on standby to kind of help. I've asked her to fact check me if I get off the rails. So Cynthia is fantastic.
Thanks, Marie.
Yeah, and I've had her on this show before. I know that you guys have expressed that you loved it when Cynthia was on. The arrogancy...
Hi, Cynthia.
The arrogancy of me is that I'm going to sit there and dominate the show when you have an attorney in the room who could probably cover it better. So Cynthia, I apologize for being a show hog, but we already talked about this. I know you're ready to jump in when I need you or if I need you. And I know it may be late for you guys, or for you, Cynthia, out there. So I'm not sure how it's going to work out. But when you fall asleep, you fall asleep. If you're here, it is what it is. All right, tonight is going to be 100% about Luigi Mangione. And again, I had prepped a show tonight that would be probably a good hour and a half worth of show based on stuff that I was already planning on doing, which is called basically a primer to the court cases. What I want to do is I want to cover for you all the court dates that are out there, the 3 different jurisdictions, explain that a little bit to you in concise terms, and explain to you how certain dates have moved, have changed, and some of the insights that I have learned as well on some things that maybe I've misstated a little bit and I want to correct. So we're gonna cover the court cases, the 3 jurisdictions. We're gonna explain those. We're gonna explain the charges. We're gonna talk a little bit about the attorneys. We're gonna talk a little bit about the judges. If you haven't heard much about Judge George Caro, who's presiding over the New York State case against Luigi. If you haven't heard much about him, you're going to learn a lot new things about George Caro. I'm not saying bad or good things. You're going to learn new things you want to know. If you are interested, by the way, if you are interested in these cases, you're going to want to know how Judge Caro is perceived in legal channels. And we're going to cover that and show you how some new things that maybe you don't know about Judge Caro. We're going to talk about Catherine Parker. She's a magistrate for New York. We're going to explain a little bit the difference between a magistrate and a judge, and well, she is a judge, but what a magistrate judge is versus the district judge and so on. We're going to explain a little bit things. This is a channel that's not only about educating you about the case, but also educating you as best as possible about the legal system, our judicial system, how law enforcement works, the whole ball of wax. So it's a very, very educational, at least that's what I intend to do, a very, very educational series. I want to let you know again that we will cover Karen Agnifilo's bombshell motion that she submitted today. We're going to cover that, and I'll tell you briefly about it before I cut out of it. We're going to go briefly because I cannot read Karen Agnifilo's words without getting kicked off of TikTok. That's my belief. There's no way I can tell you what Karen filed without getting suspended. I've already been suspended once for a week. I really don't want to get suspended again. So I feel
so bad we have to walk on eggshells.
I understand, but this is their platform, TikTok's platform. They don't want us to talk about certain things, so we will respect that, and we will not talk about it. So again, at the end of this show, at the end of the TikTok portion, I will tell you that it's the end of the TikTok portion, and then we will then shut off the TikTok stream, and we'll be 100% only on YouTube, and that'll be the too hot for TikTok part where I'm going to get into taking the gloves off. So again, I'm going to be very neutral in my approach on things to avoid getting suspended from TikTok. And then after we've gone through the neutral stuff, I'll take the gloves off for YouTube because I don't think we can really do that here. And I ask everybody to keep your fighting, bickering, and everything in the chat down to a minimum. Because I don't want to get us in trouble on the channel. So again, thanks everybody. And by the way, gifts and everything are very, very much appreciated. I don't even know what the gift values are, but if you throw gifts out there, we super, super appreciate it. All right. And if you want to follow the channel and you're not, make sure you're following the channel and on YouTube. Okay. On YouTube, you should see our disclaimer. It's all the legalese that I've started to add, which is basically reminding you that when I'm reading from copyrighted material, that's considered fair use. All right. So I'm going to go ahead and also show you on YouTube the What's New section on my website, which will have, and again, I don't know why it's so slow. I got super fast internet. But here you see a section on my website called What's New. There's April 11th. I talk about the TikTok stream. I talk about how I've done a recent review of the Koberger story.
Hey,
huh?
Can you adjust a little bit? Your green screen is making you fade in and out a lot.
Yeah, I can only kill the green screen. I can kill it entirely, and then I won't do the flickering off and on, or I can leave it on.
Now it's good.
Well, yeah, because I'm not moving a whole lot.
I see.
Yeah. And the only reason I want to keep it up is because, again, I'm directing people to the website up there. That's going to stay solid. It's just me that's going to flicker in and out. So if you don't mind me being a ghost every once in a while and kind of zooming in and out, bear with me because I'm learning. I need a sound and a video editor. Anyways. So I want to remind you that I've been doing a new book review on the Kohberger case, When the Night Comes Falling. It's a Howard Bloom book. I'm doing a review of that. There's a link to that on there. I also recently did, and this is important to the Luigi case, so I'm going to mention this now. I also did a chapter review, chapter 7 of the book An American Sickness by Elizabeth Rosenthal. Now I'm careful even mentioning her name. This is when I got shut off of TikTok for a week last time, when I was in the process of talking in part about that book. So I'm not sure, TikTok's not really 100% clear on what exactly I got violated for. They think they've been clear. I don't think they've been clear. But what I want to point out to you is, if you are interested in hearing alternative motives for the Brian Thompson situation, you want to be sure that you are understanding an issue that has to deal with United Healthcare's purchase of a company called Change Health. And the domino effect that happened with the investigation by the Department of Justice.
Sarah, he did.
So you're going to want to get boned up on if you don't know, the investigation of the Department of Justice into United Healthcare for the purchase of Change Health. I talk about this in length on Chapter 7's review of my series I call Luigi's Bookshelf. It's where we're reviewing the book American Sickness, because Luigi Mangione allegedly said in one of the mini documentaries that's been put out by about Luigi Mangione allegedly said that if you want to understand more about the healthcare system, you should read Elizabeth Rosenthal's book. I have been doing that. I have taken up the mantle to do a book review. Chapter by chapter, I'm going through her book. You can listen to all 7 chapters that I've done, but chapter 7, starting at about 32 minutes and 28 seconds, I go into a very, very detailed explanation from her book talking about Change Healthcare. And then I relate it to the Luigi Mangione, Brian Thompson / United Healthcare situation. So if you want that for some background information, again, that is too hot for TikTok. I can't go into the details here, but if you want to watch that video, and if you don't want to listen to the first 30 minutes of it, you can skip ahead to 32 minutes and 28 seconds and start getting into the description of what happened from my understanding of United Healthcare purchase of Change Health and the Department of Justice investigation around that, which also then really ties into Brian Thompson and Andrew Whitty from United Health Care and United Health Group, respectively, selling off massive amounts of stocks before the Department of Justice investigation was announced, and therefore being sued for insider trading. If all that stuff sounds crazy to you and you have no idea what I'm talking about, yeah, right, shady. If all of that stuff sounds crazy and you have no idea what I'm talking about, you have some education to do, go check out that video. All right. We're going to talk again about the 3 court cases, jurisdictions. We're going to talk about all the important dates and recent changes. We're going to talk about what's next and what my predictions are. We're going to review the Q players, and then we're going to have open questions and answers. After the open questions and answers, I will then announce that we are closing down the TikTok feed, and we will be only streaming then on YouTube. It'll be the same exact feed that's going on YouTube right now. We're just not going to cut the YouTube feed. We're just going to cut the TikTok feed and then move on to the Too Hot for TikTok part, where we will talk about the following things in the Too Hot for TikTok area, which is going to be a description about what Agnifilo Infiltrator or InTrader. Why is Karen Agnifilo's company called Agnifilo InTrader? If you don't know that, and we're going to tease it a little bit in this part, but I can't even explain to you what it means and what my analysis of it is on TikTok. So you'll have to hear that on YouTube. If you want to hear my breakdown of Pam Bondi versus Karen Agnifilo, you're going to need to go to the YouTube channel and wait for the Too Hot for TikTok part. If you want to hear me relate how this all relates to the Snowden, yes, Snowden, the supposed traitor against the United States who leaked government documents. If you want to know how that relates, in my opinion, to this case, you're going to have to listen to that on YouTube and not during the Too Hot for TikTok section. And lastly, if you want a detailed analysis of the Change Healthcare situation from my understanding, you'll need to go to the Too Hot for TikTok section at the end of this show. Now let's get into that. That took longer than, it took only about 7 minutes. That's not too bad.
Sarah had a question. A statement, I guess. She said CNN is doing a documentary about misinformation, and a part of it is that is going to be about Luigi's supporters.
CNN is doing a document about misinformation, and part of that is going to be about that's fantastic. I have been interviewed by a podcast also to try to explain to a podcast on why people support Luigi Mangione. I'm hoping to hear that podcast come out soon. Somebody asked me on YouTube, can I know what time I'll be discussing the motion by KFA? I'll discuss it briefly in just a moment, and then I'm going to go into a huge
Hi on YouTube, my foe.
Yeah, I will go into a huge review of the document, probably in about an hour and a half. But it's not hard. It's not hard set in stone. It really depends on how long the Q&A section it goes and all those things. So when I cut the YouTube feed, which will probably be in about an hour and a half, or not the YouTube, when I cut the TikTok feed in about an hour and a half, I will start getting into the Karen Agnifilo's motion in detail. But I will talk about it briefly right about now. KFA's request or motion. It's, again, Karen took the gloves off. Karen took the gloves off in her motion before the federal government, the federal case, the Southern District of New York, and basically is requesting, almost demanding, that the government immediately remove the death penalty from the table. And then she's not doing it for reasons of, hey, my client's insane or anything like that. No. She's doing it because she alleges massive misconduct. I have to be neutral when I say this. She alleges massive misconduct on the part of the federal government, specifically the U.S. Attorney General. And I have to be careful because last time I was talking about the U.S. Attorney General, I got shut down. So I'm going to be neutral. I'm going to tell you that the things that she accuses, that Karen Agnifilo accuses the U.S. Attorney General on, I was already going to talk about tonight, and I will talk about it in part. But I was going to talk about it very neutral because I'm terrified of getting kicked off of TikTok. But Karen takes the gloves off, and I will take the gloves off at the end of this when we shut down and go to the too hot for TikTok area. All right. So it's huge. It's huge what she did. If you want to know what Karen said, why they need to take, and I believe she has made a massive case for taking the death penalty off the table. I want to also tell you.
And she is pissed.
She is livid, and rightly so, in my opinion. If you also want to know my opinion, do you think, Mr. Advocates, Mr. Lee, Mr. Advocates, do you believe that they're going to execute Luigi Mangione? No, I do not believe that's going to happen. Let me point out several things. The state of New York does not believe in the death penalty. They haven't done a death penalty case since 2004. They basically have ruled it unconstitutional. The state does not believe in the death penalty. And Karen Agnifilo made a great argument that the federal government trying to double charge this case so that they can get the death penalty in a state that doesn't believe in the death penalty is beyond ridiculous. And she uses much stronger language. And again, we'll get to that when we get to the too hot for TikTok part. So one, no, I don't think Luigi Mangione is going to get the death penalty. If he does get the death penalty, let me tell you this. It takes a long time in this country to carry it out. There will be appeals. The process will go on for 20 years or more. In that time, many things can happen, including a different, and I don't want to make this political, but a different administration can come in the United States. A president can pardon somebody on their way out. Now you think, why in the world would a president pardon somebody of such a nature? Well, we don't know. Things are going to be crazy in this trial. So I don't think that Luigi is going to get convicted. That's my prediction number one. He's not going to get convicted of the death penalty. I think that Karen's made a great point, and I think Karen's going to have a real good chance of getting the death penalty pulled off, but we'll see. It all depends on how the judge feels about her argument, which I think is fantastic. So I believe that she's going to get the death penalty pulled. Even if she doesn't, I don't believe a jury is going to convict, because then not only does the jury have to convict Luigi Mangione of the crimes, but then they have to then reconvene and say, now do we believe in the state of New York that doesn't believe in the death penalty, that the only proper sentence for somebody who did this is the death penalty. So it's a two-part thing. They have to agree that he did it, and then they have to get together and agree that the only appropriate sentence is death. I don't see that happening in the state of New York. So there you go. There's my take for those who want to know, do I think they're going to get away with the execution or the whatever of Luigi Mangione? I don't believe so. I believe that what he's at most facing, personally, is life in prison without the possibility of parole. That is probably, unfortunately, for those who want to see him free, is probably what he's gonna get. My prediction is that he's probably going to get life in prison without the possibility of parole. But we believe in the presumption of innocence until proven guilty. And one of the things I will tell you in the early stages is that even Karen said, we are not We are not admitting that Luigi Mangione did something. We're not conceding that he did something. We're simply stating what you tell us that he did. So it's the first time I've heard Karen Agnifilo articulate, they're not going to say, yeah, he did it, but it was okay, or yeah, he did it, but. She's literally saying, we're not saying he did it. Now, she's not saying he didn't do it. She's just saying, I want to be clear, we're not saying that he did it. So let's that was, by the way, Luna from TikTok, that was in a footnote on the 33-page motion that we're going to discuss in the Too Hot for TikTok area. A little footnote in where she said, by the way, we are not admitting that he did this. And that was clearly in there. I'm not sure what the lagging means. That sucks. Again, if you're watching TikTok and YouTube, there's a massive lag. You're going to want to kill the audio feed on one or the other if you're watching on YouTube, kill the audio feed on TikTok. You will have a huge lag. All right, so you all are clear. I think you all are clear why it is I cannot talk about Karen Agnifilo's motion any more detailed than what I did. It was huge. It was because I just talk fast. I'm sorry, Kim's like, why do you talk so fast? It's what I do. I've talked fast my entire life. Here's the great part. If you wait till it's recorded, then you can watch at 2 times slower speed and it'll sound normal. I understand. I will, but unfortunately I can't slow down, because if I do, I will then stumble all over myself, because this is my rhythm. All right, so let's talk about the jurisdictions. For those people who want a little primer, a little update, there are 3 jurisdictions in which Luigi Mangione is facing cases. There is the state of New York, and I want to clarify, the state of New York has already indicted Luigi Mangione. What that means is a grand jury has been convened in the state of New York and has decided that there's enough evidence to proceed to trial. It is not a guilty verdict. It is we have seen the evidence against Luigi Mangione, and the state of New York agrees that there's enough evidence that we should go to trial. The state of New York will be going first. The federal government has allowed the state of New York to prosecute Luigi Mangione first. In second position, another trial will take place in which the federal government, after the state is done, will then prosecute Luigi Mangione for essentially the same crimes, but adding the death penalty involved. This is part of what Karen Agnifilo, again being neutral, Karen Agnifilo has complained about, is you're basically double charging him just so that you can bring in the death penalty, and it's inappropriate, and she explains why in legalese. So we'll talk about that. By the way, I want to remind you, we have an attorney in the room. So if you feel like you need a fact check, go ahead and put it in the TikTok channel. I don't know that she's watching on YouTube. So in the TikTok channel, go ahead and put in a question. And if it's something that you think or she thinks or we think that should be clarified, we can have her come on and join us for an audio portion. What else? Then the federal government. So the federal government is second. That jurisdiction over Luigi Mangione has not indicted Luigi Mangione. So what does that mean? That means the federal government has not formally stated that a grand jury is willing to say, yes, you have enough evidence to proceed to trial. Now, I would say they have been unable to obtain an indictment against Luigi Mangione. My theory is that if they were able to obtain an indictment against Luigi Mangione, they would have already done it, which to me suggests, and I could be wrong, and maybe my attorney friend in the room would have a different take on it. But my take is that if they could have indicted him by now, they would have indicted him. So the fact that we don't have an indictment in New York says something in itself.
Someone wants to know, is there a deadline for them to reply to today's motion?
Yes, there is a deadline to reply to today's motion, and I will cover that a little bit later, I think, because I don't have the date memorized on the top of my head. But we will get into it in the Too Hot for TikTok section. Okay, so we've covered the state of New York, the federal government in New York, which again, the federal government is essentially the same charges, but it includes things that are required to bring in the death penalty. Things like commission of a murder, using interstate commerce. So using a public bus, public transportation, public highways to drive from one state to another adds the federal element involved. So if the murder had all happened within New York City, if that had happened, then the federal government wouldn't be able to get involved so easily. But because allegedly, the shooter allegedly had to cross state lines in order to do this and stalked, allegedly, his victim from across state lines, then that allows the federal government to jump in and essentially have all the same charges, but adding, hey, because you did this from another state, we can now bring in the death penalty. essentially. Only on one of those charges, by the way. And then last but not least, we have the Commonwealth of Pennsylvania. And I want to teach you a little bit about what does that mean, Commonwealth of Pennsylvania? Why is it State of New York and Commonwealth of Pennsylvania? In this channel, I'm going to give you education. I'm going to give you, I bet you didn't know this, maybe. All right, so let's talk about and so by the way, the Commonwealth of Pennsylvania is basically holding. It reserves the right to try Luigi Mangione if and when, the New York state trial is over and the New York federal case is over. And if they didn't do their job and Pennsylvania feels like it, they'll get him on the gun charges and the false ID charges and things like that in Pennsylvania. So they're kind of in the lesser position, awaiting and basically ceding their position, even though they were the first to arrest Luigi Mangione in Pennsylvania. They're basically allowing the federal government to take charge and determine what order things happen in. And the federal government has determined the state will go first, then the federal government will go next, and then Pennsylvania basically is going to wait to decide if they're going to try him or not. But there's a key date coming up in the Pennsylvania case. So confusing. I would recommend, by the way, if you want to know the details, get a pad of paper out and a pen. I got lots of dates. Some of these dates are on the website luigimangione.info.com, which is, thank you super much for the gift, by the way. A lot of the dates are on there, but I'm also going to explain how dates moved, what they mean, and where we're at in the process, from my understanding. I could be wrong. That's why I have some backup in here in case I get wrong. Let's talk then now about the 11 charges Luigi Mangione faces. I'm not going to enumerate every single charge, but there's 11 charges in the state of New York. Luigi faces, among them, first-degree murder in the furtherance of terrorism. That's one that's been bugging a lot of people. What do you mean terrorism? Because they allege that he basically terrorized a nation or a group or an entity, such as the healthcare system, which is critical to the United States, right? And so by doing that, he has committed an act of terrorism per the New York State charge, first-degree murder in the furtherance of terrorism. In addition, he's got a charge of second-degree murder. You would think first-degree murder and second-degree murder could be like wrapped into one. Is either first degree or second degree. But no, we got the second degree murder, we got first degree murder in the act of furtherance of terrorism. We've got criminal possession of a weapon, forgery, and stalking. Those are basically the categories that the 11 charges in the state of New York. Forgery, yeah. So probably for presenting a false identification to the hostel when he was using the ID of Mark Rosario. So that was a forged document, they're claiming, and they're probably getting him on forgery for the forged document of a false identification to the hostel. That's my guess. I didn't read it specifically, but that's what I'm guessing. Ridiculous. So 11 criminal charges in the state of New York. We covered those. Now the federal government's charges. Federal government charges are essentially these 5 basic categories. Murder through the use of firearm, and that's the big one. Murder itself, not a death penalty in the federal government's eyes. Murder with the use of a firearm is. So apparently you can beat somebody with the baseball bat, and that's okay. Well, it's not okay. You'd still get life in prison without the possibility of parole. But the point being is that there's a little bit of irony that suddenly if you add a gun to it, it's the death penalty case. So murder through the use of a firearm, this charge carries the possibility of the death penalty. That's the big one. That's the one that Luigi's facing for worst case scenario. If you don't consider life in prison without the possibility of parole, not worst case scenario, it's the death penalty. And that one is the charge. Also, in addition, the federal government is charging him with the use of a firearm in furtherance of a crime of violence. That just, again, seems redundant. So the murder with the use of a firearm and use of a firearm in the furtherance of an act of violence. Wouldn't you call murder an act of violence? It seems redundant, but it's a separate charge. Stalking. Stalking, again, basically is referring to the idea that Luigi Mangione had to have been watching this individual, planning this attack, premeditated, and in addition was using interstate commerce of some kind or transportation or internet searches to track and stalk his victim. Allegedly, again, Luigi Mangione has the presumption of innocence until proven guilty in a court of law. And then also stalking resulting in death. Seems redundant, doesn't it? So we have a stalking charge as one of the charges of the federal government, and then stalking resulting in death as a separate charge, like we'd need that. Then use of a silencer in a crime of violence. So those are the charges essentially from the federal government. The big one, again, the one that you really want to pay attention to, is murder through the use of a firearm. That charge carries the death penalty. That is what the federal government is going for, according to the U.S. Attorney General, who has directed the state of New York, the federal government in the state of New York, to seek the death penalty. All right. So, and now let's talk the Commonwealth of Pennsylvania. Now, I told you I would tease a little bit of why it's called the Commonwealth. Why is it called the Commonwealth and not the state? Just a bit of trivia. A few states, there are 4 states, Pennsylvania, Kentucky, Massachusetts, Virginia, those are the 4 states that have chosen to use the Old English term from back in the Old English days of a commonwealth instead of a state. It technically in our system means the same thing, and it carries the same weight and has no difference. But they have, for basically nostalgia purposes, kept the title of the Commonwealth of the people. So it's the Commonwealth of the people of Pennsylvania instead of the state of Pennsylvania. Just a little bit of trivia. It doesn't mean all that much more, but it's interesting to understand why is it that it's the state of New York versus Luigi, but it's the Commonwealth of Pennsylvania, not the state of Pennsylvania. That's why. It's just a little, there you go, little nidbit. Okay, here are the charges in the Commonwealth of Pennsylvania versus Luigi Mangione. Carrying a firearm without a license, so it's a firearm charge. Possession of instruments of a crime. Forgery, again, and tampering with records or identification. You would think that sounds redundant. Forgery and tampering with records of identification. Isn't that the same thing? Well, here's where the slight nuance might be from my understanding. Forgery involves creating, altering, or using a false writing with the intent to defraud or deceive. Tampering with records involves knowingly, alternately destroying, concealing, or falsifying records, documents, or identification to mislead or hide the truth. It sounds very similar. I'm guessing, and I don't know, maybe other people know for sure, that one forgery charge has to do with the driver's license, and one tampering with records of identification might be to do with the passport that he allegedly had on himself. So if he had a passport in the name of Mark Rosario, they might say that he altered an existing document like the passport and that he created entirely a fake ID and the driver's license. One is forgery, one is tampering with a record of identification. And that's purely a guess. And then we have false identification to law enforcement. If you've watched my channel long enough, I have talked ad nauseum, big word, right? I have talked ad nauseum about the fact that Thomas Dickey, his attorney in Pennsylvania, said that was not illegal for for Luigi Mangione to provide. Thanks for the gifts, by the way. It was not illegal for Luigi Mangione to provide false identification of police officers because it's only illegal in the Commonwealth of Pennsylvania when you have been informed that you are under investigation. And Luigi Mangione was not informed that he was under investigation for 17 minutes of his interrogation, including times that he was told to stand up, put his hands on his head, be frisked, had his items taken from him, all while not being told that he was under investigation. And no, it is not presumed you're under investigation because you're being patted down and searched. That is not the case. The courts in the Supreme Court in Pennsylvania has declared it clearly. That is not, you can't just presume that you're under interrogation. You have to be told you're under interrogation. He was not told for 17 minutes. And therefore, at the time that he presented the false ID, I told you I've covered it already, and I didn't need to probably go into that detail.
Okay, breathe for a second. Okay. So Ask Why wants to know, it says, but New York and the feds seem to be waiting to hear from the Pennsylvania judge.
So, I have said that many times. I have said many times that it appears to me. So we're going to talk about this. These are part of the important dates. We're going to talk about whether or not the federal government is waiting for the decision from the Commonwealth of Pennsylvania on whether or not Luigi's arrest is going to stick. I now might have a slightly different opinion on it. It might be Karen Agnifilo who's actually waiting for the results in Pennsylvania to find out if it's going to stick. And I'll explain why I kind of changed that thing. But whatever the case may be, the Commonwealth of Pennsylvania has to make a decision by the 16th of April on whether or not Luigi's arrest was legal. And then the federal government in the state of New York is going to have to make an indictment or do something 2 days later on the 18th. And I have theorized that the federal government probably wants to know if that arrest is going to stick. Do they have the items that they have on them? Conversely, Karen Agnifilo may also want to know, are those charges in Pennsylvania going to stick? And what does the government really have on him? So we're all waiting to find out what's going to happen. And that is a directive by a judge in the Commonwealth of Pennsylvania that the Commonwealth must respond by the 16th. All right, let's talk about dates, important dates. All right. By the way, I want to show you on YouTube. This is Luigi Mangione's official website, luigimangione.info.com. This is maintained by his legal defense team. You can see it says Luigi Mangione Legal Defense Information. There is a section across the top that says Case Updates. If you click on that, you look down here, there's the litigation calendar. It shows the upcoming dates. The 18th, that's the federal government. That's the federal government waiting for them to make an indictment of Luigi Mangione or to drop it. Or to let him go, or whatever. But the point being is they've got a deadline to make an indictment by the 18th. Then you've got the Commonwealth. Let's skip down there. The Commonwealth of Mangione, what's not listed on a date here is that they have until the 16th of April to decide whether or not his arrest was legal. And I'm going to explain that in detail coming up as well. And then you've got Thursday, the June 26th, the People, New York State versus Mangione. That's in June 26th. But we're going to talk about things have kind of moved around. But on this website, luigimangione.com, they've done a great job of showing you links. There's the federal case updates. You can click on that. It'll take you to, and I'll just do it right there. Look at that. There's the court listener. It's got dates. It's got PDF downloads. If you want to know where I get all my information, this is where we get this information. Going back to this page, you've got the state of New York cases. And there's the state of New York update filed, whatever. So this right here, by the way, the federal case update, the U.S. Mangione case 124 motion right there that I'm going to click on. I was going to say that was going to be this big motion that got submitted today, but we're going to cover that in detail coming up. And again, in the Too Hot for TikTok. So anyways, those are your dates, and let's explain a few things. So let's go to April 9th. All right. So originally, April 9th was the date that the defense had been given to file the pretrial motions in the state case. So before the trial, both the prosecution and defense have an opportunity to file pretrial motions. Things like pretrial motion to toss the whole case out, to suppress certain evidence, to review the fact that an arrest may not have been legal. It's things that happen pre-trial to say, hey, we think the arrest was illegal, we think this is illegal, we think you overcharged, we think whatever. These is all part of the pre-trial. April 9th was the date that the defense had been given to file pre-trial motions. Karen Agnifilo, the attorney for Luigi Mangione, had requested a 75-day extension of this deadline because she needed more time, in part because the federal government has not coughed up basically all the discovery that she needs. And she was denied. She was denied, well, this was the state case. She was denied by Judge Caro, the state judge. And this is what I want to show you here. This is the actual article, cbsnews.com. This is Luigi Mangione's court date moved to next month as lawyers challenge the evidence for his arrest. I want to point out something that I kind of did a little wrong. And no, I don't think J.P. Renison did it, by the way. Thanks for asking on that question. Luigi Mangione, this is reading from the, again, if you're on YouTube, you can see, I'm going to blow this up on YouTube a bit so you can see it on my screen a bit better. Luigi Mangione, accused United Healthcare CEO killer, was scheduled to appear in federal court Wednesday, but his hearing has been pushed back to next month. Meanwhile, his legal team in both New York and Pennsylvania claims his rights were violated when he was arrested in December. So they say he wasn't read his Miranda rights and his DNA was collected illegally. His DNA was collected illegally in that arrest because, first of all, the arrest shouldn't have happened, is what they're saying. Therefore, the collection of his DNA also is illegal because he shouldn't have been arrested and swabbed and fingerprints taken when they did the whole, like, hey, you want a snack? You want to hold this bottle for me? Thanks, I got your prints. They did that kind of maneuver to him. So lots of more people have joined. Maybe you should do another plug to how you're doing this tonight. Yeah, so I'll just let me finish this document and then I'll cover a little bit what we're doing again. At his last court appearance in February, he sat attentive, wearing a bulletproof vest and shackled. And I got to close this ad. Defense attorney Karen Agnifilo expressed concern that she was missing the bulk of evidence, saying it was an infringement on his right to a fair trial. And the judge set an April 9th deadline for the defense to submit pretrial motions. That's the April 9th date you saw, and gave prosecutors until the 14th. The judge is expected to rule on the motions on June 26th. That date's also on the calendar. So there's where your original April 9th date was. And then we have this April 10th date where the court held a brief video conference with attorneys, and basically the defense motions were are to be filed by April 23rd now, and the people are to respond by May 28th. And the people also are required to file a motion of protective order by April 10th. By the way, that was yesterday. We'll talk about that in a moment. I know this is a lot. This is a lot of information. The parties are to appear in court again on June 26. So now we have the amendment motion schedule. Defense motions are to be filed. So the defense can file their motions, pretrial motions by the 23rd, and the people are to respond by May 28th. In addition, there was a part during this trial in which discovery wasn't handed over about certain witnesses because the prosecution, who has an obligation to tell the defense who's testifying against their client and what they're going to testify to, the prosecution made an argument that they cannot do so because they're afraid for the lives of some of their witnesses. And so because they're afraid of some of the witnesses, they're afraid that fans of Luigi Mangione or others will commit an act of violence against people if they know who the witnesses are. So they wanted to file basically a request to suppress that information of who the witnesses' names are and issue a protective order against those witnesses so that the names don't have to be released. They needed to submit, according to the court, they had to submit their request for protective orders against certain witnesses by yesterday. Nothing has been posted on the website that I see that says that they did so. It is possible that those things are still being submitted. I'm sorry that you're tired. You're not going to make it through this tonight. Oh, this sucks. This is a long one. Watch the recording, hopefully. Anyway, so they were going to be required to do a protective order by yesterday. Nothing's shown up. We don't know if it's still coming. And so that's the big if. We don't know if there's anything like it coming. And what does it mean, really? It just means that the prosecution, again, is trying to keep us from knowing who the witnesses are because they're afraid. Okay, sorry about that. All right, so let's move on to some more discussion. The Commonwealth of Pennsylvania's decision on Dickey's motion to suppress.
Dicker's going to make it. She's fine.
I saw that. So the Commonwealth of Pennsylvania, Judge Jackie Bernard of Blair County Court of Common Pleas, that's the Commonwealth of Pennsylvania, ordered the Commonwealth of Pennsylvania to ordered the Commonwealth of Pennsylvania to respond to Thomas Dickey's omnibus pretrial motion within 30 days. That created a deadline of April 16th. So what that means, when Luigi Mangione was arrested in Pennsylvania, allegedly with the murder weapon, allegedly with a manifesto, allegedly with a confession letter, allegedly with thousands of dollars in cash and a passport as if he was about to flee the country, all those things allegedly were found on Luigi Mangione, that entire arrest may have been illegal. Thomas Dickey, his attorney representing him in Pennsylvania, submitted a pretrial motion to basically toss out. It's called a writ of habeas corpus. He's basically saying, let go of my guy. You have no reason to detain him. Now, technically, he's not in Pennsylvania. He's in federal custody. But basically, the Pennsylvania court system is holding a reserve on Luigi's butt when everybody else is done with them. And he's basically like, let go of that. You can't hold my guy. You can't detain him. You can't keep him in a court trial system because the entire arrest was illegal. When he made that motion, there was possibly no traction on it and no deadline. So a Judge Jackie Bernard, came out and said to the Commonwealth of Pennsylvania, you must respond to this. Either agree to it or suppress and toss it out. Either say the arrest was illegal or say it was legal, but you got to make up a decision and put it in writing by the 16th. So that's coming up in just a few days. It is a huge one. Was that arrest illegal? Now here's the difficulty that for those who want to play devil's advocates, because that's the name of the channel. Just because a judge decides that it's okay, that it was legal, doesn't mean it really was legal, but we have to trust our court system. So if the judge says, I think it's legal, all of us can bitch and moan all day long because Thomas Dickey made an amazing argument on why it wasn't legal. It looks like it was illegal to all of us, but if a judge looks at it and says, no, that's totally legal, we're required as Americans to accept the judge's opinion. We're to believe that our judges are impartial. Now, that doesn't mean that we don't have appeals processes in the United States where judges are accused of not being impartial. That happens all the time. People are like, look, that judge was not impartial. They clearly had it out against us. They had already decided our client was guilty and they were going to let everything fly that the prosecution asked for and nothing that we asked for, and it wasn't a fair trial. And then other people will review that, an appellate court will review that and say, yeah, we think that judge was probably a little biased. You get a retrial with somebody that's not so biased. So that could happen.
Somebody wants to know if there's something on April 18th.
April 18th April 18th, which is a couple days after the 16th deadline, is the date that the federal government is supposed to officially indict Luigi Mangione. And again, I find it interesting that it's a couple days after the Commonwealth of Pennsylvania has to decide whether the arrest was legal or not. So somebody's waiting to find out, in my opinion, whether or not that arrest was legal and what information or what evidence they have against Luigi Mangione in New York. So again, I want to point out here, this was an article from Insurance News, Newsnet, and it says, I'm trying to get to the key point that I had on this. In a document filed by the city's Southern District, the judge accepted a request from Mangione's lawyers, married couple Karen and Mark Agnifilo, asking to delay the hearing by 30 days to allow adequate preparation for pretrial proceedings. So again, I have stated many times that the prosecution keeps delaying, and Karen keeps agreeing to their request to delay. In this case, it was clear from this article, at least in Insurance News Net on March 18th, a relatively recent article, that it was Karen, it was Mangione's own lawyers who asked for more time, asked for an additional 30 days for the adequate preparation of pretrial proceedings. So just to get that clear,
thanks, Sticker.
that was a request by Karen herself. All right, so here's, we're going to talk now about the attorneys in the case. And again, I want to point out, this is Karen's website. This is Agnifilo Intrator. We represent individuals in complex and sensitive criminal matters. And maybe I'm just think differently than other people are going, what the hell's an intrator? Like I have a fairly decent vocabulary. What is an intrator? I've done some research, I've done some studying, and intrator is not actually a word, but it has meaning. And here's what you're just going to have to trust me. The meaning is a too hot for TikTok issue. Because to explain to you what it means and how it's significant to Karen Agnifilo and her legal team, I have to explain a topic that will be perceived as being discriminatory. And so I will have to explain that to you in detail on the Too Hot for TikTok. But if you've ever been curious and you don't know the answer to why Agnifilo Intrator is the name of her company, Agnifilo Intrator LLC, that's the partnership of herself, her husband, Jacob Kaplan, why that's called Intrator, and you don't know why, I can explain to you my theory why, but not on TikTok. All right. So let's talk a little bit about Karen Agnifilo, for those who aren't familiar. Now, most of you by now are familiar with Karen Agnifilo. Prior to establishing her company, the Agnifilo Intrator LLC, she was a chief assistant district attorney in Manhattan District Attorney Office from 2014 to 21. What this means for us is she's well versed in how the prosecutions or the district attorney's office works. She has worked as a district attorney's office from 2014 to 2021. She oversaw major criminal cases and played significant roles in shaping the office's policies. She helped basically form their playbook. She knows their playbook. One can argue that's a good thing for Luigi Mangione. His attorney knows all of the tricks and all of the tactics and all of the tools available to the district attorney's office because she was a district attorney all the way up to 2021, very, very recently. So she is right in there. Mark Agnifilo, he's co-counsel of P. Diddy, believe it or not. In the same detention center where Luigi is kept, he's representing Mark Agnifilo as the primary counsel for P. Diddy. Now, I don't support, out of all the people that you want to presume innocence, I'm not sure I can get behind presumption of innocence on P. Diddy. It's the one area I would be like, man, even I, in the total belief that we are presumed innocent until guilty in a court of law, have a hard time with the P. Diddy one. Even so, Mark Agnifilo is the primary counsel for P. Diddy, Sean Diddy Combs, and co-counsel to Karen Agnifilo, and co-owner, presumptively, of Agnifilo Intrator, a partner in that business. So you will see Mark Agnifilo's name on things, you will see Karen's name on things, you will see Jacob Kaplan's name on things because they are all in that same legal department. Some people have mistakenly said, oh, did you see that Mark Agnifilo has replaced Karen Agnifilo as Luigi's attorney? That is not the case. Karen Agnifilo is still, to my understanding, his lead counsel. Mark Agnifilo has his hands full as lead counsel on Sean P. Diddy Combs and is co-counsel to Karen on this case when he has time to advise her and help out with those things as well. So that's how that relationship works. We talked about Jacob Kaplan just briefly. We don't need to know a whole lot about him right now. And then we're going to talk about Avraham or Avi Markowitz. So Avi Markowitz is part of Luigi Mangione's legal team. He is not a member of the Agnifilo Trader. He's not officially there, but he is part of Luigi Mangione's legal team. To be fair, that was appointed by Karen Parker herself. And so there's been a lot of problems with Karen Parker as a judge, and I will get into that in detail when we talk. I'm going to talk about some of these key players. We're going to talk about Karen Parker, the judge, the magistrate. We're going to talk about George Caro and the issues. But to be fair, she is the one who, by law, appointed Avi Markowitz to be special counsel, a special counsel. Why? Because Avi's specialty, Avi's specialty, is death penalty cases. And in states where the death penalty is on the table and in the death sentence is on the table, it is required that the counsel be provided a special counsel who specializes in death penalty cases. That is Avi. So his legal team brought on a death penalty specialist, not because Luigi Mangione, as I might have suggested in a really, really early video, not because Luigi Mangione lawyered up some more and bought another high-powered lawyer. He literally was appointed it because it's required in a death penalty case. Special counsel Avi Markowitz.
So somebody just brought up something that we didn't know. So Trader is somebody's name.
I will explain that. I will explain that in the too hot for TikTok area. Let's not go further than that.
Right.
That is somewhat true. But there are reasons why you will find, if you stay for the too hot for TikTok area on YouTube, why we didn't talk about it on TikTok. I'll make that clear when we get over there.
All right.
All right. So Karen Parker. Let's talk a little bit about. Let's talk about. I didn't talk about. So we talked about Judge Caro. No. I'm sorry, we've only been talking about Karen Agnifilo's team and Avi Markowitz. And then Thomas Dickey is his Pennsylvania attorney. So there's the attorneys, all of the attorneys you need to know for Luigi Mangione. Karen Agnifilo, lead counsel, Mark Agnifilo and Jacob Kaplan, her co-assists, and also special counsel Avi or Avraham Markowitz. Thomas Dickey is the attorney in Pennsylvania. You can be assured Thomas Dickey and the whole Agnifilo Trader team are working together as they're keeping their whole, just like the federal government and the state of New York and the Pennsylvania are also, all those prosecutions are working together to share information, which may or may not be totally good or proper in certain areas. But we'll get into that kind of stuff at a different day, not tonight. All right, so let's talk about Judge Caro in the state case. This is the one that should concern you a little bit if you are wanting Luigi Mangione to have a favorable outcome. So Judge Caro, New York State, is a former prosecutor in Manhattan. He focuses on narcotics and homicide cases. He is appointed as a criminal judge by then Mayor Rudy Giuliani, and we don't need to hear what your opinions are about Rudy Giuliani because I know that's a controversial subject, so let's just leave that alone. He was appointed by Rudy Giuliani as a criminal judge. Judge Caro is known for, and we're going to read some of this. I'm going to read it from an article. Actually, what I'm going to do is I'm going to read the article first to tell you what the highlights are. And you're not going to, if you're a Luigi supporter or you believe in the presumption of innocence and you want to see this come out well, some of the things about Caro are going to make you a little bit, that's not good. In fact, they refer to getting Judge Caro as a bad draw. If you're in a legal defense team and you find out, hey, who's the judge assigned to your case? We got Judge Caro. Ooh, bad draw.
All right. Talking about Jayoma. I don't know what that means.
Who?
Jayoma?
I'm not sure. All right, so let's talk about Caro. This is from AOL.com. Luigi Mangione's New York judge George Caro is tough on crime and sympathetic to victims. December 19th. This is very early on. Luigi Mangione's New York judge Caro is described as tough on crime and sympathetic to victims. Lawyers call him a no-nonsense guy, and some say he leans pro-prosecution. So again, If you are in support of Luigi Mangione, you probably don't like hearing that this judge has been known to be favorable to the prosecution. Caro has allowed, here's where you do want to you pay attention. If you're, I'm going to blow this up on YouTube so you can see it bigger. This is something in your favor if you are a believer in transparency. Caro has allowed video and still photography in his courtrooms during past high-profile proceedings. So Judge Caro has a history of high-profile cases, and he has allowed video cameras in his case. Everybody keeps asking me, do you think we're going to get to watch the case? Do you think we're going to get to watch the case? And I've been saying, I don't think so. New York State usually doesn't have cameras in the case. However, Judge Caro, according to this article in AOL.com, has a habit of allowing cameras in his courtrooms, even in high-profile cases. That's a win if you want to have a fair trial and you want to be able to question what's happening in our legal system. So consider that one good for you. His cases, however, have been earned tabloid nicknames, including rape cops. That's good for Luigi Mangione in a way, too. A killer nanny, a blowtorch hubby. In 2021, he presided over the mopped hit-and-run death of Gone Girl actress Lisa Baines. So he's had some high-profile cases. And the rape case, rape cops, and by the way, I keep saying that word, and that's a word you get in trouble for. So let's stop saying that, I guess. A former Manhattan narcotics and homicide prosecutor, Caro was appointed to Manhattan's criminal court bench in 1998 by then-Mayor Rudy Giuliani. We talked about that. Caro was the son of retired Associate Justice John Caro, who in 1979 was the first Puerto Rican appointed as an appellate judge in New York. Doesn't really have hit or miss on that, but here's the part you don't like. Tough draw. The younger Caro is known among defense lawyers at Manhattan Criminal Court as a tough draw. If one lawyer tells another in a courthouse hallway, I just learned that my guy is going to be in front of Caro, another might commiserate. Wow, that's a tough draw. Veteran attorneys in the city told BI. So in other words, you kind of get this random draw system of what judge you're going to get on the day that your docket comes before the court. And it could be this guy or it could be somebody else. There was a 50-50 chance. They got Judge Caro, and people in the defense system will say, ooh, tough draw. You got Caro. That's not good for the defense. He's pro-prosecution. Prosecutors might say the opposite of Caro. Prosecutors would say he's a good draw. So if you're a prosecutor, oh, we got Caro. That's good for us. So that's bad if you are in the camp of presumption of innocence for Luigi Mangione. This is a pro-prosecution judge. I don't think, I want to say that for the record, I don't think there's any shenanigans here. It's not like they picked a pro-prosecution judge because he was pro-prosecution and they just have it out for Luigi. It was a luck of a draw. That's why they're literally calling it a bad draw. You had a 50-50 chance of getting one or the other. You got the one that's pro-prosecution or known for being pro-prosecution. Kuby called Caro harsh but not crazy, as Manhattan criminal judges go. 5 Manhattan defense lawyers interviewed by Business Insider said that the judge leans pro-prosecution. None would say so on the record because they may have cases before him in the future. So they're even afraid to call him pro-prosecution because they've got cases in front of them. Okay, I just got a notice from TikTok that I had to prove I was a human, so hopefully you didn't get a huge delay why that happened.
Oh, you scared me. I was afraid it was something else.
Oh yeah, no. We're not in trouble yet. The most common descriptor. The most common descriptor among lawyers reached by Business Insider is he's no nonsense. He's a tough judge, said a former fellow jurist, Charles Solomon, a state Supreme Court justice in Manhattan who retired in 2017. Very firm, very fair. That's what we want to hear. That's what we want to hear. Very fair and well respected by his colleagues. All I want is a fair trial. That's all I want. I just want a fair trial. So he's known as very firm, but very fair. So let's hope that very fair is a good thing. All right.
So someone says that Karen could make moves based on knowing that judge's tendencies from when she was a prosecutor.
Certainly, like that point was made. Certainly, Karen Agnifilo is well aware of Judge Caro, I'm sure. So she knows his tendencies. She knows a lot about him. So yes, that's a good thing on Luigi's side, as she's well aware of what Judge Caro is likely to or not do, and probably even has case in point. Hey, by the way, you've ruled before on this case this way, so you should probably rule this way again.
And Mifo says that Caro did get him the laptop, so that's a good thing.
Yes, right. He did say that it was okay for Luigi Mangione to have a specially configured laptop. So again, we want to believe Judge Caro is going to be a fair judge. It's just that he leans pro-prosecution according to everybody, and they consider it a bad draw in the defense team. Okay, what likely happened was that on December 4th, the day of Thompson's shooting, Mangione's lead prosecutor, Joel Seidman, happened to be on call to catch new homicides. Seidman's team of prosecutors feeds all new cases into one of only 2 courtrooms. One of them was Caro's. This is typically the way cases get assigned. So they're just pointing out, this wasn't like, hey, we want him to get the hardest judge possible, let's get him Caro. Literally, it just happened that was what happened that day. He's a solid guy, someone said. He's a very good trial judge. In general, lawyers could do a lot worse than Judge Caro.
Someone brought up a point. Isn't there a female judge, too, on the case where Luigi wears burgundy?
I believe what you're talking about is Catherine Parker, the federal magistrate. We will talk about Catherine Parker next. So this is a really long show. Apologize for that in a way, but yeah, we're going to get to Catherine Parker, the federal magistrate, next. All right. So at sentencing, Caro was empathetic, advocate of law, order, and victims, and as many news clippings show. I can only imagine and this is one of the things that he stated, I can only imagine what memories are haunting the victims in this case and his significant other, he said last year in a recent high-profile sentencing for a random attempted slashing murder of a French tourist. In other words, he's very sympathetic to the victims and how they feel. And so the victims and the victim's family, again, he may be over-sympathetic to the victims and not to the accused. In 2011, Caro presided over the trial of, here's where it's good. This is good for people who want to hear good and bad on George Caro. In 2011, Caro presided over the trial of NYPD officer accused of raping a young, fashionable executive, a woman he'd been dispatched to help when she was too intoxicated to get out of her taxi. So, Judge Caro has overseen corrupt NYPD officers who have done illegal acts in the performance of their duties. This is good because he knows that this can happen. A jury, not the judge, a jury cleared the officer of the conviction of the rape and convicted him of official misconduct for 3 caught-on-video visits he made to the woman's apartment during his shift that night. So they didn't find him guilty of actually doing the crime, but they saw that he was going to her house multiple times and they convicted him of inappropriate behavior. Judge Caro oversaw that. It was the conviction of a bad cop, if you will, that had done bad things. And so it's not like he won't go in your favor if there's shenanigans. Police misconduct offenses rip at the, and he even stated, this is one of his statements, policemen misconduct offenses rip at the fabric that holds us all together, Caro told the former officer, Kenneth Moreno, before sentencing him to a year at Rikers jail. So Caro was not sympathetic to the cop. He was like, hey, look, you're an officer and you violating your oath as law enforcement rips at the fabric of America. So that's a good thing. If the prosecution is going to state that there were shenanigans on behalf of the NYPD, this judge is not very excited about NYPD besmirching the reputation of law enforcement. So that could go in your favor if you're looking at it that way. Again, I'm just giving my reading between the lines, what I think that means for you. You, sir, ripped a gaping hole in the fabric of the community, the committing of these crimes. It was Caro's biggest media case until now. Moreno's lawyer was one of the lawyers to call Caro no nonsense. Not easy on defendants or defense lawyers for that matter. Honestly, it doesn't matter what judge has this case, the former criminal attorney for President-elect Donald Trump added. There is such overwhelming... Now this is horrible. I hate this paragraph. Honestly, this is referring to Luigi Mangione. Honestly, it doesn't matter what judge has this case, the former criminal attorney for President-elect Donald Trump added. There is so much overwhelming evidence of guilt here. It is not a whodunit. It was he sane when he did the case? That is horrendous. Horrendous. You should have the presumption of innocence until proven guilty in a court of law. He's stating there's no question the accused did this before his day in trial, before his first day in trial. No question he did it. It's just now a matter of whether or not he was sane when he did it. For the record, I do not believe Karen Agnifilo, in fact, I don't believe it's possible for Karen Agnifilo to submit an insanity plea. They are not going to submit an insanity plea or any kind of defense plea that includes the idea of some kind of mental disability, handicap, or reason of insanity. That's not on the table, but this guy seems to think literally the evidence is overwhelming of guilt, and it's not a matter of who done it, because he knows who did it before his day in trial, and so now it's just a matter of whether he was insane or not. That's disgusting, in my opinion. And again, I'm not even saying that Luigi did or didn't do it. You need to presume innocence. That's how our system works. In his most high-profile murder, dubbed the Killer Nanny case, I don't think we need to go through that one. We don't need to go through that one. That's just extra stuff that I thought I was going to cover, but on the sake of time, because I got so much to cover tonight, because we haven't even touched yet on Karen Agnifilo's big motion, we're going to skip that case of the nanny. All right, we're going to close that up for now. We're going to close up we'll leave InTrader because we're going to talk about InTrader later. Let's talk briefly. You don't need to look at that screen, so I'm going to just kind of put us over here on this splash screen for now on my website on YouTube. Let's talk about that federal magistrate of Catherine Parker. This is the magistrate and what the difference is between a magistrate and a district judge. So Catherine Parker is not a trial judge. She's not going to be presiding over the trial of Luigi Mangione in the federal case. She is a magistrate, which is kind of like saying an administrative judge. She helps out with things like issuing search warrants and those kind of things. And she's presiding over some of the pre-trial things, the charging of Luigi Mangione, the official charging of him and bringing the charges against him, and setting of bail. It's just procedural, administrative kind of stuff. It's not the actual presiding over the trial. Catherine Parker will not be presiding over the trial. So let me clarify some of the problems that people have had. Initially, Catherine Parker came under scrutiny even by myself, in which I made a video on TikTok saying that Karen Parker should recuse herself from a judge because of conflicts of interest. The reason why I said she had conflicts of interest is that Judge Parker is married to Brett Parker, who was vice president and assistant general counsel of Pfizer until he left the company in 2010. Pfizer, as you know, is a pharmaceutical company. It's in bed with health insurance companies. It is part of the healthcare system. And therefore, having your husband be part of the executive board of Pfizer could be in itself a conflict of interest. In addition, her and her husband both hold stock in Pfizer as well. So now they're shareholders with a financial investment in whether or not Pfizer's stock goes up or down. So let's follow the logic. If this case for some reason becomes an indictment of the U.S. healthcare system and healthcare companies across the board take a dive,
Be careful.
Catherine Parker and her husband would stand to lose stock money because they're invested in that system. So some have indicated, thank you for telling me to be careful, by the way, Rhonda. Some have indicated that that would be a conflict of interest. All judges have to declare their withholdings and investments, what they're invested in, so that you can understand as a people whether or not there's a conflict of interest. This is for the whole purpose of saying, hey, you shouldn't be presiding in a case about this when you hold stock in that company. So there's that. Additionally, they have both her and her husband have retirement plans that have investments in other health insurance companies, which may or may not include United Healthcare. So again, people have concerns about Catherine Parker presiding over a trial or any proceedings that have to do with the healthcare system at its heart, when she may be invested in and financially incentivized to make sure that the stock price doesn't go down at health insurance companies. Now, here's the positive thing about that. Catherine Parker, in my opinion, has made no major decisions in this case that actually changes the outcome of anything. So at first I was thinking, oh my gosh, this is the judge who's going to oversee the trial and she's got stock in the health insurance industry. You can't have that. She is not. She is not going to preside over the trial of Luigi Mangione. In fact, the federal judge who will be assigned has not been assigned yet. We don't know who it is, but I assure you it will not be Catherine Parker. She's a magistrate. She's not a trial judge. So she will not be that. But what she has done, to clarify, is she basically did the initial appearance in detention. She conducted his first court appearance in Manhattan. She informed him of the charges against him. She even did something that was for the defense by basically discussing, she issued a formal order under Federal Rule of Criminal Procedure reinforcing the government's obligation to disclose all exculpatory evidence to the defense as established by Brady versus Maryland. So this is called Brady information. So this order emphasizes the importance of a timely and complete evidence sharing to ensure a fair trial. So let me break that through the universal translator. Karen Parker basically reiterated the prosecution must share information with the defense, especially and always if it is exculpatory, meaning it could show that the defendant didn't do what he's accused of doing. You need to be reminded. You can't just hide stuff from the defense because it might help the defense's case. You need to share everything with them, and you need to share it in a timely fashion. Keep in mind, That timely fashion thing has been agreed by both sides to keep extending and extending and extending. But she on the positive side, she was like, look, you have an obligation here. She also was the one that basically appointed the death penalty council. So she was the one that recognized that this was a death penalty case. Death penalty was on the death sentence was on the thing, and so she approved the addition of Avi Markowitz to the defense team and appointed him as part of their special counsel. That's only a good thing for the defense. It's only a good thing, so there's nothing bad there. And then lastly, she granted the continuance. In March 2025, Parker granted a 30-day continuance, rescheduling it for April 18th. It was originally April 9th, so she allowed a continuance. This decision was made in response to a request from Mangione's defense attorneys, Karen and Mark Agnifilo, who cited a need for additional time, and she granted it. So let's put aside, for the moment, the idea that we need to be terribly worried if you're a believer in Mangione's innocence, that Karen Parker is going to be the problem. Because again, Catherine Parker is going to be the problem. She is not going to be presiding over the trial. And again, everything that she's done to this point hasn't really affected the trial, in my opinion, besides maybe not allowing bail in the case, which I think in this case was understood. All right. Actually, I think that we are through a lot of everything I was going to talk about for my first hour. Look at that. I did it in an hour. So maybe this won't be a 3-hour show. What that means, let me tell you what that means now. What I want to talk about in detail are the things that I can't talk about on TikTok by my own form of censorship. I have been suspended for 1 full week on TikTok for something that I don't know what I did, but I think I have an idea, and they called it hate speech. And I understand, I guess, what they probably were thinking was hate speech. And now that I think, I have to guess, because we can't have a conversation and they won't clarify for me, because I think I know what it was, I'm not going to do that again out of respect for them, because they made it clear that's a violation, or they made it as clear as they can. Again, they didn't make it clear. They just said, hey, you were talking hate speech and we're not going to allow that. I don't hate anybody. Like, when did I do hate speech? I'm just giving analysis of the news. I'm literally reading Karen Agnifilo's statements, which I will not do again, because I think it was reading Karen Agnifilo's statements that she made to the press or officially in response. I think that's what got me in trouble. So we're not going to do that on TikTok. So what I'm going to do is I'm going to close TikTok, and I'm going to thank everyone on TikTok who is here tonight. But I want to ask you, if you are interested in hearing my detailed analysis, which will probably take about an hour as well, of Karen Agnifilo's massive. Thank you so much for the teddy bear. That's so cute. It's so cute on TikTok. Thank you. So if you want to hear that detailed analysis, you're going to need to make sure you're tuned into YouTube. The channel up here is Devil's Advocates 2024. You can see it right there. Go over there to, and when I took the screenshot, I only had 260 subscribers. I have like 360 subscribers now. I need to refresh that screenshot. It makes me look even smaller than I am. No, don't even go there, Rhonda. Anyways, and so we're gonna go ahead. We're going to go ahead and I'm going to shut down. We're going to talk about, let me tell you what, in case you want to go to YouTube, what we're going to talk about. We're going to talk about what I believe Agnifilo intrader means and why it's kind of interesting. We're going to talk about Pam Bondi's basically announcement from the press about Luigi Mangione and how it was improper. I was going to already discuss that. I was already going to discuss that on Too Hot for TikTok before today's motion. We're going to talk about Karen Agnifilo's initial response to that. I was already going to talk about that on Too Hot for TikTok. And then we're going to talk about the big, huge Karen Agnifilo motion where she really blasts the whole Pam Bondi situation. I shouldn't have said Pam's name. The whole U.S. Attorney General's situation. So, again, last chance. Devil's Advocates 2024 on YouTube. I will be shutting down now on TikTok. Thank you all for joining me tonight. I'm sorry that you TikTokers are not going to get to hear much of my analysis of Karen Agnifilo's motion. You heard a little bit at the beginning. I wanted to do that so you'd have some idea. I think it was a bombshell. I think Karen made a fantastic case. I think any judge in their right mind should rule in her favor and take the death penalty off the table. That's my analysis of Karen's thing in the neutral position. Now, if you want to hear me take the gloves off, we're going to shut down TikTok and join me over on YouTube. Thanks to everybody and have a great night from TikTok.
Thanks for coming to TikTok. Hopefully we'll see you on YouTube. Be sure and like and subscribe. Thank you.
All right, so we're off TikTok and we are on YouTube only. Hey, YouTubers. Thank you for waiting for me. I don't know what kind of audience participation we have over here. It looks like we got 35. That's a good number. That's a record number for my YouTube streams at the moment. So thank you so much for doing that. So let me tell you a little bit about why I'm saving the best for last, which is this big, huge document review of Karen Agnifilo's massive omnibus motion. And by the way, is Cynthia still there? Damn it, I just cut out of YouTube without even saying thanks to Cynthia. I'm an ass.
No.
Oh my gosh, I owe her.
Hopefully she joins you over here.
I owe her a massive apology. Holy crap, I can't believe I just did that. Here I had Cynthia on hold the whole time, and I never invited her up to the table. So yeah, very, very soon, Michelle, the fun's going to start when we get into that document. But let me talk briefly about Agnifilo InTrader, why I can't talk about it on TikTok, in my opinion. So InTrader, oh, fantastic. Unfortunately, I can't give you the mic here.
Yay.
Shit. How do I give her the, did you have, Cynthia, if I can find out, do you want to take the mic to, not that you can correct it on TikTok, because I'm done on TikTok. Oh my gosh, I'm so sorry, Cynthia. I'm really sorry about that. I got so wrapped up in the story, I forgot all about it. And thank you so much for hanging out with us. I just want to give you an opportunity. Is there a way for me to get you on here? Do you want to get on here, or are you just kind of hanging out until you fall asleep? Or did I say something wrong already that you just like you type in and I could say, hey, yeah, maybe I need to get her on a special show. What the hell was that over there?
That was my cell phone.
Okay. Okay, she doesn't need the mic. So yeah, again, my apologies. I'm so sorry. I hope you didn't stay on just in case I needed you and then I didn't need you. I feel horrible. All right, let's talk about Agnifilo InTrader. All right. InTrader is not technically a word. It's considered basically an honorific surname or a title associated with those who interpret the law. It's specifically a Judaic term, a Judaism term. This is the reason why I didn't want to say it on TikTok, because if I start talking about Jewish things or Judaism, and I've got a hashtag on TikTok called conspiracy theory, anytime people associate the word conspiracy and Jews, they lose their mind. And I don't trust TikTok to not lose their mind when I point out the following things. And it's not from a conspiracy angle. Please understand, this is not a conspiracy angle. It's just interesting to know. Karen Agnifilo, formerly Karen Friedman, is of Jewish descent. Her co-counsel Jacob what was the last name? Jacob Kaplan is also Jewish by ancestry, and also Avraham Markowitz is Jewish by descent. Her husband, while Italian, Mark Agnifilo, probably can be presumed to be in the Jewish circles, considering that she has often represented Jewish clients, supported Jewish things, Jewish ideals, basically causes that are supported by those of the Jewish faith and nationality, as well as Avri Moskowitz. Both of them have represented cases of Jewish nature or basically importance. So that's why InTrader, and it was an interesting tidbit because I'm a person who thinks, and I asked the question, why InTrader? Apparently, like during the Roman occupation of Jerusalem and stuff like that, when they would require basically Jews to identify themselves by a surname, a last name, one of the last names that some of them used was InTrader. It was basically a surname, like a last name, and they used InTrader, and it basically referred to somebody in a basic, maybe a form of Yiddish or something like that. I think they said to somebody who is basically learned in law, specifically sacred law, meaning the sacred text, like the Torah. I know a bit about this. I spent a lot of time in Christianity and Judaism by extension in some regards. And so it just was interesting to me. So if you ever wanted to know what the hell InTrader means, it's because Karen and her legal team are of Jewish descent. The InTrader word has a Jewish heritage, and it has something to do with sacred law keepers or interpreters of the law. So there's something maybe you didn't know.
So here's a couple, I don't know if you're reading the comments in YouTube.
I haven't.
A couple items of note. So there's a United Healthcare Department of Justice lawsuit.
Yes.
Okay.
Yeah, is that a question or a statement somebody's making?
It says, and the United Healthcare Department of Justice lawsuit. Maybe something else was said that I missed.
Yeah. Yeah, so that was Ask Why was asking about that. Caro comes a bit... So yeah, we talked about the that, and I will talk about it if you want after everything is said and done. I have a section on Snowden and Change Healthcare. Change Healthcare has to do with the whole Department of Justice thing. But I'll save that for last because I know everybody's been waiting for my analysis. No, InTrader is not one of the partners' last names. The names of the partners of Karen Agnifilo or of Agnifilo InTrader is Karen Agnifilo, Mark Agnifilo, Jacob Kaplan, and that's it. Those are the names of the individuals.
Who is Zach InTrader?
Huh?
Who is Zach InTrader?
I don't know. Again, that was used as a surname, like a last name at some point in time for some people, but I don't believe it's her legal team, and it has to do with the meaning, I believe.
It looks like there's a partner. He's on LinkedIn.
Oh.
Zach InTrader, partner Agnifilo InTrader LLP.
Well, here's her website. Here's the lawyers. Let's look down just real quick.
I just did a search for Zach InTrader because somebody mentioned his name, and that's what I found.
I don't want to spend a lot of, lawyers. Here you go. Lawyers. Mark Agnifilo. There you go. There's a Zach InTrader. I will tell you again, this is a surname which has to do with interpretation of law. And it's Mark and Karen Agnifilo's main law firm. So he may be a partner, a founding partner, as it says right here. That's interesting that his last name is InTrader, but I don't believe it's not the full story. Again, the surname has a significance in the Jewish thing. And I would bet you dollars to donuts, Zach InTrader is also of Jewish descent. Gregaros is probably not. Manzi, probably not. I'm just thinking by names of Jewish descent. Maybe Manzi, but I don't think so. Anyways, so good catch. There is a Zach InTrader, but I don't believe that they named the whole law firm after that guy because InTrader, again, is a title. It's like an honorific. So moving on. Good catch, though. Good catch. All right. So let's talk about the fight between Pam Bondi, which I don't want to talk about on TikTok, and Karen Agnifilo. Briefly, this is what I was going to tell you. So Pam Bondi, United States Attorney General. In my opinion, she has a requirement of the United States Attorney General to presume innocence until proven guilty in a court of law. It is perfectly fine if Pam Bondi wants to direct the federal government with a direction like this. In cases which people are accused of a sentence worthy of the death penalty, we would like you to honor the federal government's position of seeking the death penalty in those cases. Perfectly fine. She has every right to do so. What she did, however, was make this statement. Actually, this is the one. Sorry, this is the one from the Department of Justice. And she said in her opening statement, Luigi Mangione's murder of Brian Thompson, an innocent man and father of 2 children, was premeditated, cold-blooded assassination that shocked America. That was her statement. That was her opening statement. In no part of that does that say presumed innocent until proven guilty in the court of law. There's no presumption of innocence. Pam Bondi, as a representative of our entire legal system, referred to Luigi Mangione as a murderer of Brian Thompson, end of story, who is an innocent man, and it was premeditated, cold-blooded, and an assassination. No presumption of innocence. And I beat to death. That is disgusting for the U.S. Attorney General to make that kind of statement. Now, in a sub-paragraph, she did add as alleged. As alleged, Luigi Mangione stalked, murdered, and murdered United Healthcare CEO Brian Thompson, blah, 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 blah. So she did use the word alleged once, but her opening statement was, Luigi Mangione murdered Brian Thompson in an act of premeditated, cold-blooded assassination. That may be fine for a prosecutor to do who's prosecuting the case because they're making their case. This is what we're saying the guy did, and then the defense says we're saying the guy didn't, and it's the jury's decision. That's okay for a prosecutor. She's not acting as a prosecutor. She's working as the Attorney General of the United States and should be believing in the presumption of innocence. She can direct them to seek the death penalty, but not call Luigi Mangione a murderer. So Karen Agnifilo blasted him, and I want to show. I'm not going to show Karen Agnifilo's response because she blasted him and said, no, maybe I will. Maybe I will. Let's take a moment. Statements.
Pammy cakes. Huh. I love it.
Let's read Karen Agnifilo's statement. She reiterates this in much more brutal language in the motion filed today. You're going to love it if you haven't heard it. And if you have heard it, you're going to love hearing it again. It's big. But here's her initial statement to Pam Bondi. This is on April 1st. Pam Bondi made her statement, and then this from Karen Agnifilo. This is what I think got me in trouble on TikTok. by seeking to murder Luigi Mangione. So right off the bat, Karen's firing back and saying that the government is intending to murder Luigi Mangione. You wouldn't call a death penalty sentence murder unless it was unjust, because you don't call that just, you call that, justice kind of thing. But she's saying, by seeking to murder Luigi Mangione, the Justice Department has moved from dysfunctional to barbaric. Their decision to execute...
see them in the ring together.
Right. Their decision to execute Luigi is political and goes against recommendations of the local federal prosecutors, the law, and historic precedent. She's going to elaborate on this massively in the document that we're going to review. Massively. But I want to reiterate what I said that night when I got shut off. It appears to me that Karen Agnifilo was told behind doors that, hey, we're not going to seek the death penalty in this case, so just relax. And that was part of the reason why I said maybe she was kind of like playing nice with allowing everybody more time and all these things like that, because they were telling her they're not going to seek the death penalty. Her statement and her reaction said to me, I think Karen was told on the down low they weren't going to seek the death penalty. That is exactly, people, that is exactly what happened in my interpretation of the law that she, at the omnibus hearing or motion that she filed today. It states that basically there was a transition. I want you to understand this early. There was a transition of leadership in America. We were under the administration of Joe Biden at the time that this started in December and January. When that whole thing was happening, it was under Joe Biden. On January 20th, right, President Trump took office. They changed the position from, hey, we're not going for the death penalty in this case under Joe Biden, to Donald Trump wants to be hard on crime, and he wants to make Luigi Mangione the first person they execute. And so they changed it when Donald Trump took office as a political statement. And that's part of her primary argument. This is a political stunt. They literally delayed the decision. They withheld making a decision on whether or not they were going to do the death penalty, probably telling her on the down low, we're not going to seek the death penalty. We're not going to seek the death penalty. We're not recommending the death penalty. And then when Trump took office, it's like she found out when they announced it to the press, hey, you must seek the death penalty in this case. And she's like, what the hell just happened? We've been asking for a review of this. We've been asking for your decision, and you keep telling us, wait, hey, don't worry. We haven't formally said so, but a decision's coming soon. And then they sideblinded her by saying, yep, we're going for the death penalty. When they've been tipping her off the whole time, they were not looking for the death penalty. While claiming to protect against murder, the federal government moves to commit the premeditated state-sponsored murder of Luigi. By doing this, and she doesn't hold anything back, and she gets more vicious in the next document. By doing this, they are defending the broken, immoral, and murderous healthcare industry that continues to terrorize the American people. That is huge. This was the rant that I was starting to make when I got shut off, when I was immediately cut off. Your feed has been ended. You have lost your appeal immediately. You are off TikTok for a week. Shut the hell up. Don't talk about this again. Because I was talking about how Karen just tipped off that they are going to essentially, in my opinion, put the American healthcare system on trial by calling it a murderous, broken, and immoral healthcare industry. That is huge if she can pull that off. Again, I've maintained that I don't think any judge is going to allow this to become a trial about the healthcare system. They're going to say, again, objection, Your Honor. The healthcare system's not on trial here. Luigi Mangione is on trial for the murder of Brian Thompson. End of story. And I suspect or expect a judge to say, sustained. This isn't the healthcare system on trial. You need to reword your statement. But they're going to try to work that in, I think, based on the tip-off that Karen is going to call our healthcare system in America broken, immoral, and murderous healthcare industry. Again, I didn't think that O.J. Simpson's case was going to be anything but did O.J. Simpson kill Nicole oh my God. Huh? Ron Goldman.
Yeah.
Did she, yeah, did that was going to be it. Your objection, the LA Police Department's not on trial here. Yes, they were. The LA Police Department became on trial in that case, and it became about a racist police department. So it could happen again. We are prepared to fight these federal charges brought by a lawless Justice Department, as well as the New York State charges and Pennsylvania charges and anything else they want to pile on Luigi. This is a corrupt web of government dysfunction and one-upmanship. Luigi is caught in a high-stakes game of tug-of-war between state and federal prosecutors, except the trophy is a young man's life. That was the statement. That was the back and forth that I was offering my opinions on when I was shut down by TikTok and suspended for a week for talking about it, which is why we're not going to do it on TikTok and why we're doing it on the Too Hot for TikTok. let's go ahead now and break into the document you've all been waiting for. Bum, bum, bum. All right, let's see.
You're such a dork.
I am a dork. Let's see, we're going to go...
So LLN brought up a couple things. Luigi had $20,000 put on his books today for help with his case.
Yeah, I heard that he got a $20,000 donation today.
And also they wanted to know, can the Supreme Court step in?
Probably after everything's been decided. I'm trying, oh gosh, man, tell me I didn't lose this document with all of my highlights. Oh, hold on, Luigi. Here it is. I got it. Yay!
You should see him trying to find his keys.
Oh yeah, it's horrible. All right. Okay, this was filed today. Right up here you can see the April 11th, 2025. It's a 33-page document. Defendant Luigi Mangione's motion to preclude the government from seeking the death penalty. I have tons of paragraphs that I want to read. Some of it's a little repetitive, so I'll try to avoid that. I want to highlight Avi Moskowitz on this document. He is a death penalty specialist. This is all about them wanting to seek the removal of the death, to preclude the government from seeking the death penalty. So they're asking the government to drop immediately all talk about the death penalty, and they're going to lay out the reasons why in a case of law. And Avi Moskowitz, as a special counsel specializing in death, in life and death cases with the death penalty on the line, never get in an argument with Cecilia when death is on the line. Sorry. I had to go there. Hopefully you know the reference to that. Let's go. All right, defendant Luigi Mangione motion to preclude the government from seeking the death penalty. I'm going to do a lot of reading because somewhere in here after I read all this, I mean, I was literally prepared to go for an hour and a half, and then all of a sudden they dropped this bombshell. So I'm just going to have to read it again with you and then decide, oh yeah, I was going to make this comment. She starts out with the introduction. When the United States plans to kill one of its citizens. Holy crap, Karen, are you going to start like that? When the United States plans to kill one of its citizens, it must follow statutory and internal procedures. Defendant Luigi Mangione seeks court intervention now, not merely because the government has failed to follow those procedures, but because it has abandoned them. He seeks court intervention because the Attorney General has Pam Bondi, Attorney General has explicitly stated,
Pancakes.
Yeah, has explicitly stated that she has ordered the death penalty to carry out, in quotes, to carry out President Trump's agenda to stop violent crime and make America safe again. Quote from Pam Bondi. Mr. Mangione's counsel asked for 3 months to prepare a fulsome mitigation submission to the Department of Justice Capital Committee and was ignored. What does that mean? Run that through their universal translator. So there's a committee that convenes to decide whether the capital punishment is appropriate in this matter. The defense has an opportunity to give their mitigating reasons why it shouldn't be the death penalty, and they were basically denied the ability to basically submit why it shouldn't be a death penalty case. They were basically, she outlines how they were basically blocked from doing that properly. The stakes could not be higher. The United States government intends to kill Mr. Mangione as a political stunt. That's harsh words, Karen. And it's not...
it gets the point across.
It does get the point across. She is not holding anything back. Mm-hmm. But the Attorney General's actions and public statements in this case have not followed the usual course. Because the Attorney General has chosen to proceed in this way, Mr. Mangione's due process rights have already been violated, and the manner in which the government has acted has prejudiced the grand jury pool and has corrupted the grand jury process. So what she's saying is already the grand jury that's been convened all this time and has not yet been able, in my wording, has not yet been able to indict Luigi Mangione, has now been tainted. I said I was not going to have the dogs do that again to us tonight, and they're doing it again to us. Anyways, she stated clearly that I lost my train of thought. That the jury pool, the grand jury, has been basically tainted, and all future juries have been tainted by the words of Pam Bondi, and she's going to outline exactly how, in no uncertain terms. I'm trying to pull up because my wife's away from the computer to see my live stream. All right. Mrs. Mangione is my name, sir. I get it. Anyways, so We seek two forms of relief from the court. First, because the Attorney General's direction to the Southern District of New York, that's SDNY, the Attorney General's direction to the Southern District of New York prosecutors issued publicly as a press release to seek a death sentence for Mr. Mangione is political, arbitrary, capricious, a breach of established death penalty protocol, and has now indelibly prejudiced this process, and the government should be precluded from seeking the death penalty. So she's basically stating everything that I said just a minute ago. You've already tainted everyone in America, and especially your grand jury, because now they've heard from the Attorney General herself that Luigi's guilty, and he's a murderer, that he stalked and did all these horrible things, and you need to put him to death because we are going to be hard on crime. That has prejudiced anybody. Well, if the Attorney General says it, it must be true. Second, because of the highly public nature of the Attorney General's press release directive, her follow-up on Instagram post stating plainly that Mangione is guilty of murder, and though he is still unindicted, let alone convicted, and her statement that Mr. Mangione should be executed because he committed two particular statutory aggravating factors. We're going to get into that in detail. The Attorney General has prejudiced the grand jury process in this district. Run this through again, the Universal Translator, because I read it kind of slow. She's basically saying, not only did she get a press release, she went on Instagram to show off about how she's going to go after Mangione. She called him again guilty of murder, even though he is to be presumed innocent until proven guilty. He hasn't even been indicted and he hasn't been convicted, but she's calling him a murderer. And she's doing so within earshot of the grand jury and all potential juries afterwards.
All of the public.
All of the public. Accordingly, any grand jury that is or is to be impaneled. So again, this grand jury, if they refuse to indict, let me make sure you understand this from a legal perspective. If the grand jury refuses to indict, the government can just disband that grand jury and convene a new grand jury and try again. They can keep trying to convene a grand jury that will indict Luigi Mangione until they get an indictment. There is no official limit on the number of times the U.S. government can go after getting an indictment and getting people together to agree to indict Luigi Mangione until they get one. Now, the problem is that the taxpayers at some point are going to say, this is a huge waste of taxpayer money. You've already convened 2-3 grand juries and they're not indicting. Let it go, man. So there can come a point in that. But technically by law, they can continue to try to get, and they can dismiss a jury that refuses to indict and impanel a new one and try to go for an indictment again. So her statement is, not only have you prejudiced the current grand jury who hasn't been able to indict Luigi yet, but any future grand jury, you've already tainted that pool.
So Myfo brought up something interesting about the death penalty. She said that the current acting head of the SDNY, I forgot what that stands for.
Southern District of New York.
Matthew Podolsky originally worked under Preet Bharara, an Obama nominee. She doesn't think that he's on the same page as Pam Meat Cakes.
Oh, I agree. I think all indications from what Karen Agnifilo is saying is that the Southern District of New York did not intend to actually pursue the death penalty. And it wasn't until the change of administration. I'm not trying to make this political. I'm not citing for Democrats or Republicans in this statement. I'm saying her statement is, with the change of administration came the change of plan, and the U.S. Attorney General under Donald Trump, who wanted to be tough on crime, suddenly said, I force you, Southern District of New York, to go after the death penalty whether you want to or not. I'm directing you to do so. All right. Accordingly, any grand jury that is or is to be impaneled, this is the yellow highlight now if you're following along, any grand jury that is or is to be impaneled on Mr. Mangione's case should be polled on their exposure to the Attorney General's improper statements and actions. In other words, ask people, have you already heard what Pam Bondi said? If not, or if you have, you're off the grand jury. You can't be on it. If you've heard what she said, you've already been tainted. You're off. Of course, as explained below, this impropriety of the Attorney General's conduct is clear from her obvious violation of Local Rule 23.1, and she cites that later and explains what it is and how it was violated. The Attorney General compounded this prejudice by appearing on television on Sunday, April 6th, and stating that she has received death threats for seeking the death penalty against Luigi Mangione. So now we've got a huge compounded problem. Not only has Pam Bondi called Luigi a murderer before he's had his day on trial, before he's even been indicted, she's called him all kinds of things and told people that the only thing that's appropriate is the death penalty. Then she's saying, hey, and people are now threatening to kill me because I said so, which is further prejudicing the entire jury pool. Because now it looks like Luigi Mangione is this horrible monster that everybody's rallying behind to kill everybody that might stand up against him. All right. Secondly, because of the highly publicized nature of the Attorney General's press release directive, her follow-up on Instagram posts stating plainly Mangione is guilty of murder. Okay, wait a minute. Did I already read that one? I think I already did that one. Yes, I already did that one. Sorry about that. I didn't scroll far enough. New paragraph, purple. As a result, this court should, 1, preclude the government from seeking the death penalty. 2, order that any proposed federal grand jurors be screened for their exposure to Attorney General's prejudicial public statements. 3, order the Attorney General to certify that she has read Local Rule 23.1. That's awesome. Make sure your Attorney General actually has read the law that she's violating and breaking, please. Please tell her that she has to actually read the law and certify that she's reread the law. Number 4, restrain the Attorney General from extrajudicial statements in violation of the rule. So in other words, you're not to make extrajudicial statements in violation of that rule, and she needs to be not only told to read the rule and certify that she read the rule, then stop making statements that violate that rule, that could prejudice Mr. Mangione's right to a fair hearing by a grand jury, including the grand jury's consideration of death-eligible offenses and factors. And 5, order the government to produce for in-camera inspection any memorandum, documents, and notes from the Southern District of New York's consideration of the death penalty, as well as any memorandum, documents, and notes provided to the Attorney General as part of her careful consideration of the evidence. And 6, order the government to produce
Karen is pissed.
To Mr. Mangione any emails, records, documents, memorandums, or notes of any communication between the government officials and anyone advocating for the death sentence, or any particular sentence in this case, by or on behalf of any business, corporate interest, like maybe the health insurance industry, lobbyists, like the health insurance lobbyists, or any other party, directly or indirectly. What is the universal translator of that last point? Not only do we want her to be reminded what the law is, told not to stop breaking the law, but also I want to see all the correspondence that has happened between the Attorney General's office and the Southern District of New York, back and forth, to see exactly how they concluded that it was okay to violate Mr. Mangione's rights and not give him due process of law and not let us have a proper mitigation hearing to see if maybe the death penalty was not proper. We want to see the back and forth emails, and I want it on camera, and I want everybody to see it. Karen is a pit bull on this one. Now again, the judge could tell her to pack sand. That he'd be like, nah, I don't care. Moving forward. But she's making a great case. And in the eyes of Americans who take the time to read this, I would say anybody in their right mind would have to probably, I don't know, say that Karen's got a great point.
So Tasha, I think she should have to write it 100 times.
Right, on the chalkboard. I will not violate Rule 23.1.
No, write exactly what the rule says.
Oh yeah, right. All right, let's continue on. Statements of fact. Now some of this gets a little repetitive. I may try to speed this up, but we'll see. We're only on page 6 of 33, so we'll see. Oh my gosh, can you make it? All right. You don't have to, Rhonda. We don't have a big room, so I can probably.
I got quilting to do.
I know. You can step out. You can step out if you need to. All right.
I'll sit for a little bit.
On the morning of April 1st, 2025, the United States Attorney General issued a press release attached in Exhibit 1. The title of the press release is Attorney General Pam Bondi directs the prosecutors to seek death for Luigi Mangione. I read that to you, by the way. That was the press release that we read on screen. And then there's another, she's directed the federal government to seek the death penalty in cases, in this case, quote, as we carry out President Trump's agenda to stop violent crime and make America safe again, emphasis added by Karen Agnifilo. So she's pointing out this was hugely prejudicial to call him basically a murderer and then say that we're doing this specifically to carry out President Trump's agenda.
So Cynthia says a lot of federal judges are very unhappy with the Department of Justice right now.
Oh, nice. I wish I could have you elaborate on that for us. I can't believe you're still awake and with us. If you're on the East Coast right now, I don't know if you are, but yeah, thank you very much.
I think she told us she's a night owl.
She is a night owl, I think, yeah. Okay, don't give away too much. You don't want to tell her secret life.
Oh, sorry.
All right. So, Mangione's actions involve substantial planning and premeditation, and because the murder took place in public with bystanders nearby, may have posed a grave risk of death to additional persons. Emphasis added. This is also a horrendous move by Pam Bondi, the U.S. Attorney General. She's indicating that Luigi Mangione put the lives of other people in danger. I have indicated why that wasn't the case, and Karen Agnifilo spells out exactly the same things I told you when my live got shut down. All right, so let's look at this little footnote I got highlighted. The Attorney General misstated the statutory aggravating factor, which states that the defendant knowingly created a grave risk of death to one or more persons in addition to the victim of offense. So what does that mean? So in order to get the death penalty, you have to have at least two aggravating factors, one of which I believe is that he stalked his victim, took time, planned it out. That's one, okay? And the other one she's saying is that he willingly or knowingly put other people's lives in danger. Karen Agnifilo will argue that he took steps not he, because again, Karen Agnifilo specifically states, we are not saying Luigi Mangione did it. What she's saying is, based on the facts you're presenting, the shooter took steps to make sure no one else's life was in danger. It was targeted on one individual and one individual only. And so you trying to act like he potentially could have missed and hit any innocent bystander as your aggravating factor is bullshit. It was a point blank shot on one individual at a very, very low time, busy time on the street where there wasn't a lot of pedestrians. In other words, the shooter took steps to make sure that only one person was targeted. I don't know how you feel about the situation, and that's for you to decide. But the point being is that Pam Bondi is trying to finagle the words to basically say, hey, he could have missed and shot anybody on the street, and therefore it was targeted against random people as well, which is not the case.
Cosmic has a question. Does a federal judge overrule an attorney general? And that may be a question for Cynthia.
Yeah, that's a great question for Cynthia. I mean, from what I understand, I'll take a crack at it. The federal judge is going to make the decision of, he's going to oversee. The jury ultimately is making the decision. The judge's job is just to oversee the process and make sure that it's handled and conducted fairly. And if that doesn't happen, then there can be an appeal process, which is basically, hey, we don't think this was a fair trial, we want a retrial, and then a panel will basically review, an appellate court will review whether or not the judge was biased or not. The U.S. Attorney General, I don't believe, gets involved in that situation, but maybe Cynthia can type out an answer if she's still awake. And I think she is, because she's a night owl. So anyways.
Someone also, my foe also said that he didn't take the second shot until the lady with the coffee ran away.
Yeah, and he didn't take not to get grabbed. And again, he being the shooter, not Luigi Mangione, because we don't know that Luigi Mangione was the shooter. He's presumed innocent until proven guilty. But the shooter also didn't fire the third shot until he was basically right on top of him, point blank. So all three shots, and none of the shots missed. That's the record too. None of the shots missed. All three shots hit their target. There was 3 shots fired, 3 casings left. He was hit 3 times. There was no misses. And her trying to act like he could have missed and therefore put other people's lives in danger is stretching it so they can have a second aggravating factor. The Attorney General's statements were immediately and widely reported by press outlets around the world. So her statement that Luigi Mangione is a murderer was repeated by the New York Times, the New York Post, Wall Street Journal, BBC, Reuters, Associated Press, Al Jazeera, CNN, Fox News, Law.com, Guardian, Washington Post, CBS News, USA Today, Bloomberg, Los Angeles Times, Chicago Tribune, Politico, ABC News, and countless others. Everyone in the world reported Pam Bondi's statement to the entire world. Luigi Mangione is a murderer of an innocent man and will be put to death.
Yeah,
so
wrong.
That is a problem.
So Cynthia did answer. She said that no,
they don't. No, they don't.
Right.
In other words, the Attorney General doesn't get involved in the overruling of a judge, right?
Right.
Okay. Rather than
Gotcha, my foe.
So in other words, I think what the person's point was, is let's say you get a judge that doesn't want to give Luigi Mangione, but he's not the one assigning the death sentence or declaring guilt or innocence. It's the jury. Pam Bondi can't rush in and go, oh yeah, you will anyways. That's not going to happen. Rather than authorizing the Southern District of New York prosecutors to seek the death penalty in a non-public communication, the Attorney General saw fit to direct them to do so via press releases. In other words, she could have done this all behind the scene. Hey, you guys should seek the death penalty. And that it didn't have to be said on Instagram, on national TV, and then repeated by every news agency in the entire world. In this release, she did not once say that Luigi Mangione had not been indicted for any federal crime or that these were mere allegations. She did actually, I want to say to correct, she did once say the word allegation. In her press release, she did have the word in a second paragraph, alleged to have. However, the opening statement was he committed murder. Anyways, she never once...
Cynthia did add some more if you want to state that.
Say what?
Cynthia added some more.
Federal judge can be appealed, but... federal judges can be appealed, but DOJ has recently defied judicial orders, as in the case the Supreme Court just ruled on. Abrego Garcia. I think Garcia's case was mentioned in this, and I didn't get into it, and I chose not to cover that case a lot. So, man, I wish I could have you up to talk about that one. Anyways, in this release, she did not want... Okay, we already covered that. Yellow highlight. She assured the country that she gave the matter careful consideration, but, as indicated below, when the defense asked for 3 months to conduct an albeit abbreviated mitigation investigation, an abbreviated, we cover in a footnote, we'll talk about that in a second, and prepared a submission to the current administration's capital case section, this request was ignored. In other words, the defense asked for less time than they're allowed to have to be able to present mitigating factors for why you shouldn't seek the death penalty, and it was ignored. Footnote, the defense was told numerous times that a decision was coming imminent. This, we requested a reasonable 3 months rather than the 9 months to 1 year that a more fulsome, proper mitigation investigation can take, especially in a case such as this one. So it was typical, not necessarily required, typical 9 months to a year in a high-profile case for us to be able to work those issues out. She was asking for 3 months, and she was denied and ignored. She also, Pam Bondi, I believe, called the incident an act of political violence. Political violence. And even though Mangione is charged in a complaint with stalking a single person who was not a politician or political, or even political. In other words, Brian Thompson doesn't even have strong political beliefs. So this is not a political thing. How do you say it's a political thing? Wait till you hear them say that it's that the reason why it's a death penalty is because he shot a CEO. If you haven't heard that already. The Attorney General's press release is relevant because it is evidence of the political and arbitrary nature of this decision. However, the Attorney General has not done making public statements about, she was not done making public statements about this case. Shortly after the Attorney General's press release, the Attorney General launched an Instagram account, Exhibit 2 attached. The inaugural 2 posts of the Attorney General's new Instagram account were a photograph of the Attorney General standing before the seal of the United States Department of Justice and the following message. Luigi Mangione's murder of Brian Thompson, an innocent man and father of 2 young children, was premeditated, cold-blooded assassination that shocked America. Oh, again, where is the presumption of innocence in this country? You are repeatedly on Instagram and on news and on TV calling Luigi Mangione a murderer before he's even been indicted. He hasn't even been indicted by a grand jury. And so far, a grand jury has not been able to indict Luigi Mangione.
By the way, his kids are 19 and 16.
Yeah, they like to focus on the children.
Young children.
He's the father of children. Do it for the children. These are adult children. Not that children aren't children, but again, they clearly want to prejudice people into thinking, how could you kill a father of children? Most people are fathers of something. Anyways, the Attorney General again failed to mention that Luigi Mangione, or Mr. Mangione, has not been indicted, nor that he is presumed to be innocent. I've bitched about that a million times. She did reemphasize that the decision was based on politics, specifically the administration's agenda to make America safe again. She was still not done making public statements prejudicing Mr. Mangione. Point C. On Sunday, April 6, 2025, the Attorney General appeared on Fox News Sunday. Concerning the Luigi Mangione case and her direction to prosecutors to seek the death penalty, she stated the following. The President's directive was very clear. We are to seek the death penalty when it's possible. It hadn't been done in 4 years. She's blaming the Joe Biden's administration. I was a capital prosecutor. I tried death penalty cases throughout my career. If there was ever a death case, this is one. This guy is charged with hunting down a CEO, a father of two, a married man, hunting him down and executing him. I feel like these young people have lost their way," meaning the people that support Luigi Mangione, presumably. "I was receiving death threats for seeking the death penalty on someone who is charged with an execution of a CEO." Why the hell does that matter? What? She has lost her mind. He's charged with killing a CEO. That's not a crime. Not specifically of killing a CEO. Killing someone is a crime, but not specific. There's no extra charge for it. It's a CEO of a healthcare company. That's not an extra charge. The fact that she is pointing out he's charged with killing the execution of a CEO, that is not a thing. Karen makes sure to point that out. She did. "We are going to continue to do the right thing," Pam continues to say. "We're not going to be deterred by political motives. I've seen a protester walking down the street here saying, 'Free Luigi.' I mean, this guy is charged with a violent crime, and we're going to seek the death penalty whenever possible." So she clearly is out of touch with American sentiment and doesn't understand how people could be possibly thinking that he's anything but guilty, because she's repeatedly stated he is guilty of murder. We'll try to get this wrapped up in the next half hour, but I'm on page 9 of 33. Some of it's repetitive, so maybe I'll be able to stop here in a bit. The Attorney General's television appearance was similar to her first two public statements in that she mentioned Mangione was not indicted, nor has the presumption of innocence. She emphasized for the third time that her decision to seek the death penalty was based on the president's directive, specifically that the administration will seek the death sentence whenever possible. She then invoked her personal experience, saying that she was a capital prosecutor who tried death penalty cases and that, quote, "if there was ever a death case, this is one." The Attorney General stated during her televised appearance that a reason she ordered the death sentence was because the alleged victim was a CEO. Counsel is aware of no provision in the death penalty statute or the Department of Justice death penalty protocol that allows for consideration of the social, economic, or professional status of an alleged homicide victim in determining whether to seek the death penalty. Good for Karen. She's basically saying, what the F does it matter that he was a CEO? We don't give different penalties in this country based on who you killed. But we do, because we have extra penalties for people who kill law enforcement and whatever. But it says basically nowhere in the murder charge does they say that if you kill somebody who's a CEO, it's extra. The Attorney General's pattern of public statements show that with remarkable clarity and consistency that she has ordered this capital prosecution unabashedly for political reasons, that her statements prejudiced any potential grand jury pool, and that the victim's professional status as a CEO was relevant to her decision. So that's what she's basically saying. The fact that he was a CEO is a reason why I think he deserves the death penalty. As will be shown below, her decision was also reached without any regard to the established Department of Justice death penalty protocol, which she wholly has abandoned. Case history. So I'm trying to see if we have to read this. Oh, yes, we do have to read this. This is about the arrest in Altoona, Pennsylvania. Following an investigation, this gets into the whole what shady shit happened behind closed doors that we weren't aware of. New information about the arrest and how that whole process of extradition happened. Following an investigation undertaken almost exclusively by the Manhattan District Attorney and New York City Police Department, Luigi Mangione was arrested in Altoona, Pennsylvania on Monday, December 9th, 2024. 4 days later, on Friday, December 13th, 2024, the undersigned counsel, Karen Agnifilo and Mark Agnifilo, visited him, Luigi Mangione, for the first time in jail in Pennsylvania. On Monday, December 16th, 2024, counsel informed the Manhattan District Attorney that Mr. Mangione was waiving extradition to New York to be prosecuted by the Manhattan District Attorney. It bears noting that the reason the district attorney was seeking a waiver of extradition and that Mangione agreed to one was because he was told there was no federal case on the horizon. So, someone lied or someone changed their mind. They were saying, essentially, only the state of New York is going to try Luigi Mangione, not the federal government. And based on that, they were like, okay, we won't waive extradition. We'll let the state of New York take custody of Luigi Mangione. They were told the federal government was not going to get involved in this case. Had there been a federal case, she continues, he would have been arrested by the FBI, brought to the nearest federal magistrate judge, and the case would have started in that fashion, not requiring the additional step of a waiver of extradition. Mangione's counsel made arrangements with the Manhattan District Attorney and New York State Supreme Court Justice Gregory Caro, that's the state of New York versus Mangione, for Mr. Mangione to appear in New York State's Supreme Court, Part 32, on Thursday, December 19th, for an arraignment on first-degree murder indictment returned in New York County. So he was brought to New York, had a court appearance on December 19th before the state of New York. As most of you know, who follow this case a lot, he was literally ambushed by the federal government on his way to his state appointment and surprisingly charged by the federal government. Karen Agnifilo was outraged. We know why. She was told it wasn't going to happen. She was told multiple times it wasn't going to happen, and something changed. And they preemptively went and basically detained him and charged him federally. Meanwhile, law enforcement was orchestrating the mother of all perp walks, attended by none other than New York City Mayor Eric Adams. She didn't name him there, but she will later. Oh my gosh, she named him later. As we prepared for the Supreme Court arraignment, counsel was contacted by a newspaper reporter who asked in substance whether it was true that the feds were stealing the case, because it was supposed to be a New York State case, and now the feds come in and they're stealing the case away from the state of New York. Seemingly a shock to all, including the Manhattan District Attorney's Office, it turned out to be true. So in other words, even New York Manhattan District Attorney Office had no idea the federal government was going to swoop in and take over the case. Rather than Mr. Mangione being brought to New York's Supreme Court on December 19th, like he was supposed to, he was brought to the U.S. District Court of Southern District of New York for an initial appearance on a complaint signed the previous day by the magistrate, that would be Catherine Parker. The complaint charged 4 counts. Count 3, murder through use of a firearm, charges that Mr. Mangione used a firearm during the crime of stalking and in the course of that crime committed murder. This charge carries a maximum penalty of death. So that is when the federal government swooped in and said, not good enough that New York State wants to give him life in prison without the possibility of parole. We are charging him with a count that specifically allows the death penalty. Counsel for Mr. Mangione, so, and again, Karen blew a fuse and said she was completely blindsided by that. Everyone was blindsided. The district attorney in New York was blindsided by it. It was a shenanigan by the U.S. government. Counsel for Mr. Mangione has been in regular contact with prosecutors from the Southern District of New York assigned to the case. In early January 2025, this is before Trump takes office, the prosecutors and counsel emailed about a meeting with the Capital Review Committee, so they're discussing whether or not there should be a capital case or a capital punishment case, under the prior administration, Joe Biden's administration. On Wednesday, January 8th, still before Trump's taken office, the prosecutors sent an email stating, setting the time of this meeting to be January 13th, 2025. That is well before President Trump is sworn into office on January 20th. So they're going to make a decision, and they're going to make the decision before Trump takes office, per that direction, at 11:45 a.m., and further advised the defense was free to make a written submission, but one was not required. On Sunday, January 12th, at 9:07 a.m., the defense emailed an 11-page written submission to the capital case section and the 3 Southern District of New York prosecutors detailing why death penalty was inappropriate in this case. So Karen Agnifilo filed paperwork, as she was allowed to, but she didn't have to, saying the death penalty is inappropriate and you should consider my arguments of why it's inappropriate. On January 13th, the defense made an oral presentation to members of the capital case section and the Southern District of New York prosecutors. So everyone was on board with knowing that Karen Agnifilo said this was inappropriate to do the death penalty. I think she was told they were leaning that way. It wasn't going to be a death penalty case. And then she was surprised by Pam Bondi. On January 24th, this is now after President Trump has been sworn into office. On January 24th, defense counsel spoke with prosecutors who said that there was no decision yet and the decision was imminent. And then on Tuesday, February 4th, well into Trump's administration, 2025, defense counsel spoke to the Southern District of New York prosecutors who indicated that the Capital Review Committee under the previous administration had not made a decision. So when it was under Biden, they didn't make a decision. During this and other calls, the Southern District of New York prosecutors informed the council that the current administration, now Trump's administration, had not yet assembled a functioning Capital Review Committee. So now there's going to be a new committee formed under Trump's administration, who's pro-death penalty, due to the recent change in administration. On February 4th, the court appointed Avraham Avi Moskowitz as learned counsel. Are you following so far? She's making an argument this is a political stunt. They delayed what was clearly not going to be a death penalty case until Trump took office. They delayed it long enough, telling her that, hey, a decision's coming, just wait, decision's coming. And then they went, hey, you know what? We couldn't come up with a decision while Biden was in office, but now Trump is, and we're going to reconvene a committee, and he has the death penalty.
Yeah, no.
On Thursday, February 6, 2025, defense counsel emailed the prosecutors that if the capital crime section is unable to make a decision based on our first submission, we respectfully request an additional 3 months in order to give us time to conduct a thorough mitigation investigation in order to submit additional information. So in other words, when they're reconvened or started to get a new capital crime section, they're like, hey, give us a little bit more time to give an argument to that special capital crime section. On March 12th, defense counsel spoke with the Southern District of New York prosecutors who stated that a decision on the death penalty would be reached without waiting for the defense to submit any mitigating factors. Nope, you don't get any, you're not even going to get to submit any mitigating factors. We're making a decision. And so on April 1st, the Attorney General issued the press release directing the Southern District of New York to seek the death penalty. I don't know if you followed all that, but she was screwed. No, Luigi Mangione was screwed. Screwed. They should have had an opportunity to explain why the death penalty was inappropriate. So she's going to do so now. She's going to do so in this argument. Arguments made to mitigating factors shared with the previous administration's capital case section that have been seemingly ignored. As noted, on Wednesday, January 8th, the Southern District of New York prosecutors informed the defense counsel that the capital case was available for a Teams virtual meeting on Monday, January 13th. The prosecutors further explained that because of the impending charges change of administration, because they knew that President Trump was coming in a few days, that the Monday deadline was firm. They were going to stick to it. You were going to make a decision before Trump takes office. It's firm. On the morning of Sunday, January 12th, counsel submitted an 11-page single-spaced letter. On January 13th, counsel discussed the issue raised in the letter with the Southern District of New York prosecutors and then constituted the capital case committee. The committee appeared to accept the arguments of counsel and did not push back as to any of them. Solely so the court can understand the point made, we briefly outlined here. So now, maybe we don't need to get into all this. Basically, what they're saying is they submitted to the previous counsel their argument. It was seen. They were kind of told that the decision was going to be made before Trump takes office, but instead it was delayed. They waited until Trump takes office, and now they changed their mind, and they're going forward with the death penalty. So I don't know how much I want to read of this because I'm going long, and you're all falling asleep, and I need to slap myself silly. But I just feel like all of this is so important. So we'll just keep going, I guess. Counsel argued that Justice Manual speaks precisely to a situation, precisely to a situation here as, a defendant is being actively prosecuted by a local prosecutor for the same conduct charged under federal law, where the local charges carry the possibility of life in prison. On this point, Justice Manual provides as follows. Now, let me explain the Universal Translator before I read this. What she's saying is, the precedent is that there's no reason to double charge someone if the state's case is good enough. If the state has a life in prison without the possibility of parole, and if they have a charge of murder, and they do, the state of New York can charge people with murder in the first degree. If they have that ability, there's no reason to say that their sentence, which would be life in prison without the possibility of parole, isn't good enough. And there's no reason for him to be double charged by the federal government for the same exact charge, but just so that you can add death penalty because you don't like the fact that the state doesn't have a death penalty. So that's what their argument is going to be made in here. You shouldn't be able to double charge someone where there's nothing wrong with the state. The state has a law against murder, and they can try Luigi Mangione for murder, and they can find him guilty and charge him as the state of New York deems should be appropriate for murder. You don't need to charge him twice for the same thing just so that you can get him a higher charge of death. Prior to charge, this is the law, the Justice Manual. Prior to charging a capital offense, prosecutors must, 1, carefully assess whether or not an accused is subject to effective prosecution in another jurisdiction, i.e., is Luigi Mangione possibly eligible for prosecution both in the state and the federal government? Yes. Okay. For this purpose, the legal unavailability of capital punishment in the state where the crime was committed should not form the basis for concluding the state cannot effectively prosecute the case. That is a quote from the manual. What it states is, even if there's two jurisdictions in place, you can't just say because one of them has the capital punishment in a state where it's not allowed, that's enough basis to charge it twice. And 2, thoroughly review the substantial federal interest principles outlined in JM 927 .230 and the dual and successive prosecution policies, petite policy, outlined in JM 9-2-031, and be able to articulate in the submission to the department with specific federal interests justify the charges. Priority should be given to crimes using the most harm to the nation, including those widespread impact to the community. So the whole argument being made is the state of New York has the charge of murder. They can, and it's perfectly fine that life in prison without the possibility of parole is a good enough sentence. You don't need to and you should not double charge them just so you can bring in the death sentence. In light of the New York State case, prosecutors must carefully assess whether the case is an effective prosecution. Is New York State able to effectively prosecute them? Yes. It is possible for the Southern District of New York prosecutors, a capital case committee member, or indeed the Attorney General to view the New York State case as anything other than effective. So in other words, you have to conclude the New York State is capable of trying Luigi Mangione for murder. You don't need to get the federal government involved. The state's charges, among other crimes, the crime of murder in the first degree in violation of Penal Law 125.27. This is the single most serious offense recognized in the New York penal law. The sentence for that violation of penal law is provided in Penal Law 60.06, which states in part that when a defendant is convicted of murder in the first degree, the court shall sentence the defendants to death, to life imprisonment without parole, or to the term of imprisonment for a Class A1 felony, other than a sentence of life imprisonment without parole. All right. We kind of covered this enough. It may be lost in the weeds with all the reading of the stuff. I'm trying to see if we can get something skipped, but I'm not good at skipping stuff. As the Justice Manual also makes clear, the fact that the state of New York does not currently have the death penalty does not make the state's prosecution of Mangione any less effective. That's the big argument. Just because they don't execute people in the state of New York doesn't mean that they can't effectively try him for murder and give him the sentence that is due someone convicted of murder in New York State. Indeed, the manual seems to have contemplated this exact situation and provides that a state prosecution can be altogether effective even if it cannot legally result in capital punishment. In other words, it specifically states you can't just retry somebody in the federal government because it has the death penalty. There is no indication that the Attorney General followed any of these procedures set out in the Justice Manual 9-2-1.4. She should write this on a chalkboard over and over again until forgiven. All right. Never. Okay. Rather, the Attorney General's directive, as well as her other public statements, focuses exclusively on Make America Safe Again policy, as well as her contention that death penalty was particularly appropriate because, quote, it hadn't been done in 4 years. So because Joe Biden didn't execute anybody, even more so, it's time to execute somebody, is essentially what she's saying. While a new administration must be given wide latitude to develop new and different policies to help American people, this does not include abandoning its own death penalty protocol so the government can kill a particular defendant without regard to law or settled procedures. Here's a footnote I highlighted that I wanted to read. New York State has abolished and reinstated capital punishment several times. In 2004, in People versus LaValle, the New York State Court of Appeals ruled that the death penalty violated New York State's Constitution because of a statutory direction on how the trial jury was to be instructed on the event of a deadlock. Accordingly, while the wording of the penal law continues to provide for the possibility of capital punishment for first degree, it has not been pursued in over 20 years and will not be pursued by the state of New York here. In other words, technically, New York State could do capital punishment, but they haven't done it in 20 years and they don't intend to again. The federal government does, however. The Justice Manual states that to justify a federal death penalty prosecution, the aggravating factors should sufficiently outweigh the mitigating factors. This is the big, hard part to get into. So again, you have to have two aggravating factors to seek the death penalty, and it has to outweigh the mitigating factors, meaning the things that suggest you shouldn't kill somebody and give them the death penalty. So the Justice Manual states that to justify a federal case, death penalty prosecution, the aggravating factors should sufficiently outweigh the mitigating factors. Here, they do not. Based on the filed federal complaint and other information provided by law enforcement, the only aggravating factor that can conceivably apply to is related to, quote, substantial planning and premeditation under Title 18, blah, 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 blah. None of the other statutory or non-statutory factors apply to the crime or the defendant. In other words, Karen is saying only one aggravating factor is here, not two, but you need two, only one. So Pam Bondi's trick was to say Luigi Mangione could have shot somebody by accident and therefore put everyone's life in danger, and therefore because he recklessly put everyone's life in danger, that's a second aggravating factor, good enough. In addition to substantial planning and premeditation, counsel alerted the government in January 12th letter to another factor where the defendant, quote, knowingly created a grave risk of death to one or more persons in addition to the victim of the offense. So that's where Pam Bondi, the U.S. Attorney General, well, actually, she's not in that January 12th. That's when they were trying to make the argument that he knowingly created a grave risk of danger to one or more person in addition to Brian Thompson. Again, he being the shooter, not Luigi Mangione. Luigi Mangione is presumed innocent until proven guilty. I'm losing people like flies on YouTube. Either I'm boring the fuck out of everybody or it's just plain super late. So let's speed this up a bit. So first here, the allegation is of a highly targeted shooting that took place at close range. So this is where Karen spells out why it wasn't a random attack endangering the public. And again, not saying that Luigi, look at the highlight. We are not, of course, conceding the truth of any set of facts, but instead merely reciting what has been alleged by authorities. So what she's saying is, we're not saying Luigi did this, to clarify. We're not saying Luigi did this. We're saying the shooter. First here, the allegation is of a highly targeted shooting that took place at close range. Second, the alleged shooting occurred at a time when the streets of Manhattan were relatively empty and there was little chance anyone else could be hurt, much less killed. Third, counts 1 and 2 of the federal complaint charges of stalking of a single specific alleged victim. So in other words, their count says it was the stalking of a single specific alleged victim. Indeed, the jurisdictional hook for the murder and firearms charge in counts 3 and 4 of the federal complaint are the very same allegations of stalking, again, of a single specific person. So he's charged as stalking one person and then said, oh, he knowingly created danger to everyone around him as well. You can't do both, in my opinion. Yeah, clearly the woman standing on the sidewalk drinking the Starbucks coffee that saw the whole shooting wasn't in danger. The shooter didn't turn to fire on her or the driver of the car that he crosses in front of or anyone. And it was a point-blank shot. The shooter was point-blank, didn't miss a single shot. Therefore, to a greater extent than most cases, the federal government's own theory is that in this case, that Mr. Mangione posed a threat to only one person, the person he allegedly stalked. That was by the first charges. And because it is clear that this aggravating factor does not apply, the Attorney General changed the wording to make it appear like it fit the conduct when it does not. As to the only aggravating factor that could possibly apply, substantial planning and premeditation under Title 18, there appears to have never been an instance where the Southern District of New York filed a notice to seek capital punishment where the sole aggravating factor was, quote, substantial planning and premeditation. In other words, the Southern District of New York has never sought the death penalty where the only aggravating factor was that he took a while to think about it and plan it out. They've never done it with just that only. Count 3 charges that Mangione stalked the victim with a gun by traveling to interstate commerce and murdering him. The crime itself requires substantial planning and premeditation. Simply put, it is impossible to stalk someone between states with a gun with the intent to kill the person and not also satisfy the aggravating factor of substantially planning and premeditation. So what you're saying is you can't, if you're going to say that he planned it out, you can't also say, and he crossed state lines. Those kind of things go hand in hand. If you went across state lines, then you planned it out to do so. So you're trying to double count that charge. In terms of mitigating factors, Mr. Mangione's background, so this is things that they should consider on why not to give him the death penalty. In terms of mitigating factors, Mr. Mangione's background reveals an exemplary life in every aspect. He was and is a loved and cherished son, brother, uncle, and cousin in a large, close, loving family. He was the valedictorian of his high school, where he led the robotics team in the Eastern Regional Finals. He graduated from the University of Pennsylvania in 4 years with both a bachelor's and a master's degree, so that should take 6 years. He did it in 4, in computer sciences. He spent his life playing soccer, baseball, and he ran track and he wrestled. When compared with Mr. Mangione's life of love, support, and excellence, no criminal record, the sole statutory aggravating factor pales in comparison. The Justice Manual requires that the aggravating factors sufficiently outweigh the mitigating ones. In other words, he's got no criminal record, he's a good kid, he's always been a good person, he's a loving person, he's done great things, and that should be as equal as anything else. And that whole he stalked a guy does not significantly outweigh the mitigating factors. So, because they don't, a capital punishment or prosecution is not warranted. All right, let's do a gut check. Are you guys bored to death? Are you bored to tears? I'm on page 16 of 33. Maybe we need to break this up. I want to get a gut check from the people who are in the room. Are you guys hanging with me? I guess you could always watch it later if you fell asleep. I don't know if I'm losing everybody. I mean, we still got 43, which is actually higher than I've had other times. So I guess I'll press on. I'm not even seeing anything in chat. Did I lose my wife as a support too?
I'm here.
Okay. All right. Read anything to if somebody says, shut the hell up, dude. Of course, they could just turn it off, right? All right. Counsel pointed out that the Capital Committee of the prior administration that since 1988, the U.S. Attorney in the district has filed notices of intent, NOI, to seek the death penalty in roughly 17 cases. Now, this is where I don't want to get into all the details. Basically, Karen's going to point out the times that the government has sought the death penalty and in 17 cases, and how 4 of them in particular have the ones that they carried out and actually did have nothing in relation to Luigi Mangione. And she states very specifically there were narcotics charges, drugs charges. They were involved in criminal empires. They had all kinds of other criminal records. They included torturing of human beings, killing a person in front of his.
Chat, Tasha.
Okay.
You just got 5 people telling you to keep going.
All right, we're going. So, and it includes somebody killing somebody in front of their wife and child. Those are the kind of killers that they put to death in the past. Not the Ivy League kid who's super nice and everybody is wonderful and whatever, yeah, except for this one alleged event. All right. So all but 4 defendants were charged with multiple murders. So this is talking about the.
Subscribe, please.
Yes, please. Thank you. So there, she's breaking down. I'm more encouraged to give you a little bit more detail since people are saying, please continue. All but 4 defendants were charged with multiple murders. As to each of the defendants charged with a single murder, Derek Frank, Jose Santiago, Alan Quinones, and Diego Rodriguez, each defendant had already, so the only time it's been one person, so all the 17 other cases except for these 4 were multiple murders. And in the case where a person only committed murder against one person, here's what they also did. Each defendant had already made a commitment to a life of crime by joining a violent drug gang or being involved in the sale of narcotics on a large scale. In addition, each defendant was engaged in conduct involving aggravating factors not present here. For instance, Derek Frank killed a witness to his drug activity after kidnapping and torturing the victim. Santiago was a member of a racketeering enterprise and specifically ordered the victim to be killed in front of the victim's wife and children. Quinones and Rodriguez tortured and killed an informant as part of their membership into a violent gang drug organization. So in other words, all the other 17 times were because it was multiple murders, and the only time it was a single person had clear aggravating circumstances. Aggravating circumstances. Luigi Mangione didn't torture anybody, didn't allegedly, because he didn't shoot Brian Thompson. He allegedly shot Brian Thompson. These 4 defendants are vastly distinct from Mr. Mangione for a host of reasons, only some of which we will note. First, each of the 4 defendants charged with one murder was involved in serious criminal activity, whether it be dealing narcotics or drugs or being a member of a violent drug racketeering enterprise. All of the defendants committed murder along with torture and physical abuse of victims. This was not present here in Luigi Mangione's case. Third, 2 others committed a contract killing of an informant. Of course, for the remaining 12 defendants, each committed multiple murders and did so as part of a violent drug enterprise and terrorist organization. Luigi Mangione does not fit the definition of all the other cases you've done. So, her conclusion, here's the yellow part, while the Attorney General stated during her televised appearance that if there ever was a death case, this is one of them. This is it. The state is wholly inconsistent with the historical record of death penalty cases in this district. The only time they've ever gone after the death penalty was under the case of multiple murders or people who tortured people in the commission of murder and all these other aggravating circumstances. And so acting like Luigi Mangione's case, if there's ever a case for a capital punishment, this is it, is bullshit, is what Karen's saying. I'm going to need the drink. All right. Given these facts and circumstances, the Attorney General's directive to seek the death penalty should be vacated for all 3 related reasons. First, the Attorney General has abandoned the established death penalty protocol. Second, the Attorney General's decision is arbitrary and capricious in that she has directed the death penalty where, 1, the existence of the New York County District Attorney case undercuts the federal interests in the death penalty. 2, there is only one colorable statutory aggravating factor that does not outweigh the mitigating factors. And two, this case is so far outside the realm of the cases where the Southern District of New York has sought the death penalty. Thirdly, the Attorney General's decision is explicit and wholly political. Again, I don't know that Karen Agnifilo can make a better argument. Now, granted, she's advised by Avi Markowitz, who is a death penalty specialist. So I'm sure this is the two of them in tandem. But she could not have made a better argument for why you can't execute this guy. It is complete horseshit.
Would you like some water, honey?
Yeah.
Okay.
Thank you. You're the best. Simply the best. All right. As noted, counsel was given 5 days notice before the only meeting afforded counsel with the Capital Case Committee, which was hastily assembled via a virtual Microsoft Teams meeting. In preparation for that meeting and with the limited time permitted, counsel prepared a letter that they submitted the day before the meeting. This was the only submission and the only Capital Case Committee meeting afforded to counsel. Significantly, the submission to and the meeting with the Capital Case Committee were with one existing under the previous administration. Since the change in administration, counsel has not been asked for a submission or offered the opportunity to meet with the Capital Case Committee formed by and existing under the current administration. Running that through the universal translator because I said it shittily. They had a previous Capital Case Committee. The defense was allowed to submit papers to it to tell why they had mitigating factors. That whole committee was tossed out. A new one was formed, and she was not allowed to submit anything to the new committee. And they just decided on their own they're going to go for the death penalty. This is wholesale rejection by the Attorney General herself of the protocol in its entirety. In other words, the Attorney General, who's supposed to be our example of upholding law in this country, is breaking every rule and every protocol, everything that they have stood for, and it's political. The Attorney General literally changed the wording of a second factor in her press release, ordering the death penalty to make it falsely appear that there were two applicable factors instead of one. Again, they need two aggravating factors to get the death penalty, so she falsely made it look like, by a clever wording, that there were two aggravating factors. The Attorney General's directive to seek the death penalty under such circumstances can only be described as arbitrary and capricious. Rather than relying on these reasons, the Attorney General cited the professional status of the victim as a CEO, the fact that the previous administration had not sought the death penalty in 4 years, and that her decision to order it here was due to the president's policy to make America safe again. So that's her argument. Hey, this guy was a CEO. Who cares? That's not part of an aggravating. Are you going to hand it over here? Thank you. You're the best. Thank you. All right. So so that's what she made her three arguments. It's a political statement. We want to make America safe again. And all those things. Also, if the death penalty was being ordered pursuant to policy instead of publicity, the Attorney General would not have put her directive in the form of a press release, followed by an Instagram post that effectively launched a new government social media account. So she creates Instagram. Hey, look, I'm a social media star. I'm going to execute Luigi Mangione on behalf of Trump. Oh, that was amazing. That drink of water was well needed. All right. Not only did she explicitly cite to the administration's policy to make America safe again in the original press release on April 1st, she reiterated during her televised appearance on Sunday, April 6th, that the president's directive was very clear. We are to seek the death penalty wherever possible. Mr. Mangione, I'm jumping ahead to the next highlight. Mr. Mangione starts his analysis, as will this court, from the standpoint that under normal circumstances, the Attorney General retains broad discretion in her prosecutorial decisions. And then it goes on, wow, I jumped a bunch. So I must have decided to just not go down that path. So pardon me for reading that. I didn't go down. It probably was a lot of those other cases, and I just didn't want to get into all the other cases. Dismissal of the United States versus Eric Adams. Eric Adams, the mayor of New York. This was disgusting. And I don't even know that it's appropriate for Karen to bring it up, but yet it just shows that everything in this administration's prosecutorial staff is doing things for a political statement. On February 10th, 2025, the United States Attorney for the Southern District of New York received a letter from the Deputy Attorney General directing her office to dismiss without prejudice the indictment against Eric Adams. So the Attorney General is asking and directing the Deputy Attorney General, the Southern District Attorney General to dismiss the indictment against Eric Adams because he has charges against him, criminal charges against him. They're like, drop all of them. There was no question as to the quality of the evidence or the propriety of the charges. The former U.S. attorney stated that the deal proposed by the Deputy Attorney General dismissing the charges against Adams in return for his assistance in enforcing the federal immigration laws violates, quote, common sense beliefs in the equal administration of justice and the Justice Manual and the rules of professional conduct. What does this mean, running it through the Universal Translator? Literally, Trump wants to go after immigration. He wants to be hard on immigration. Eric Adams is facing indictments and criminal charges. And so Eric Adams says, I will help you be tough on immigration in New York if you drop the charges against me. And they're like, done deal. We don't even care what the charges are against you. They're dropped. If you're hard on immigration, we'll drop all charges against you. Nobody's going to seek any crime against you. Holy shit, you should have a problem with that, Americans. You should have a problem with that. And people resigned over that. They're like, screw you guys. I'm not working for the government. Fuck you. I'm out. I can't live with myself waking up every day if that's how we're going to do things. Just totally dismiss all the charges. And because he made a deal. Well, he's going to be hard on immigrants. Woo! So I guess you can't be a criminal if you're hard on immigrants.
So you created a new word for some people today.
What did I create?
Shittily is a new word.
Shittily.
Shittily for Tasha.
Nice.
I must have been gone.
This has been shittily conducted, I'll tell you, every step of the way. The U.S. Attorney's letter analogized the Adams deal with the Justice Department to a quid pro quo. That's what they said. We're going to let him off on criminal charges if he makes it be harder on other criminal charges against other people. Quid pro quo. An improper exchange and a bribe. She noted that a member of her team was admonished for taking notes and that all the notes were collected and kept after the meeting. Significant to the Mangione case, she wrote that she was baffled by the rushed and superficial process by which this decision was reached, without her direct input on the ultimate stated rationales for dismissal. So in other words, they're just doing whatever the hell they want. Letting people go for crimes that they don't want to prosecute because, hey, you're our guy, and we're just going to let you go. And then dropping the hammer on people who don't deserve that level of prosecution because we want to make a statement that we're hard on crime. They do whatever they want. On March 12, 2025, ICE agents arrested, and I don't know if I want to get into Abrego Garcia, but this is the one I think Cynthia was talking about, Abrego Garcia. And I was going to get into it. I started to highlight it, and I decided, oh, it's just too long and it's too much to get into. But I think that was the case that Cynthia was talking about, if she's still here. She's probably out. But so ICE agents arrested Abrego Garcia without a warrant and sent him to the terrorist confinement center in El Salvador. That should be a problem. If they was a U.S. citizen, it's a huge problem. Now, ICE agents suggested he wasn't a U.S. citizen. I don't know. That's a part of the reason why I also left it alone. I don't know enough about Abrego Garcia's case. But certainly, if he was an American citizen or in America, he shouldn't be shipped off to a foreign country for detention so where he can be outside of our legal system. 6 years earlier, he had been granted withholding of removal, meaning that an immigration judge had ruled that he should not be returned to his country. In other words, he should stay in the United States. His detention, therefore, and removal were unquestionably illegal and without proper process. So basically, he was granted the ability to stay here, and then they shipped him out of country anyways. Some people want me to get into the Abrego situation. Unfortunately, I didn't read enough of it to figure out which parts I want to get into, and it's so sad that you think that I should get into that. Damn it. Do I read it? Maybe I have another paragraph here. Just as U.S. Attorney resigned, along with several other officials due to the egregious violations of process, a government lawyer was punished and put on administrative leave for being candid with the court over the lack of removal order for Abrego Garcia. So somebody stands up for Abrego Garcia and they're terminated. U.S. Attorney resigns over the bullshit. It's a major deal, as someone said, a major deal. Ultimately, this government lawyer was on the right side of the law as the Supreme Court last night upheld the district court's ruling requiring that the government facilitate Abrego Garcia's release from custody in El Salvador. So the Supreme Court has said, bullshit that you shipped Abrego Garcia out of the country. Get him back here. You violated the law. That's the case. That case is a lot. They defied a federal judge's order. Oh my gosh. I mean, I highlighted parts, but to be fair, I missed the mark. So I'm sorry. wish you could have the mic to really give it the due justice that it needs. It sounds to me like Abrego Garcia was illegally sent out of the country and then ordered by the Supreme Court to be returned to the country because they were doing illegal shit, and people resigned over it. People got fired over it. It's a big deal. I agree. But maybe we need to hit that harder on another night. Maybe, Cynthia, you can do a live and you can tell me when you did it, or you can do a video on it, and then I can share that and post it. Shittily is actually in the Urban Dictionary. Fantastic. Fantastic.
So you did make up a word.
Nice. All right. It's an Urban Dictionary, though. It's not an official word, but hey, fantastic. All right. This conduct highlights this Attorney General and other leaders in the Justice Department have demonstrated a track record of abandoning the process wholesale. When others in the Justice Department insist that the established processes be followed, they are either fired or forced to resign. Wow. These are not normal times. By directing the Southern District of New York prosecutors to seek the death penalty without affording even a modicum of process to Luigi Mangione, by fashioning this order in the form of a press release, followed by an Instagram post, followed by prejudicial television appearances, the Attorney General is being consistent with the new culture of the highest levels of Justice Department, one that values personal will over process, publicity over discretion, and partisan politics over justice. Bam! That's a big paragraph. That's a big, again, will a judge care? Will the right judge care? The right judge is going to care. Will this judge care? Who rules on this one? Do you know, Cynthia, who's going to rule on this motion? Anyways. Is it Caro? Oh, no, it's not Caro, because this is talking about the death penalty. Caro's in the estate, right? All right. This is admittedly an unusual procedural setting to ask for the court's assistance. Certainly, the prevailing wisdom would be that counsel awaits an indictment. They await. So that the normal procedure is wait until you have an indictment. Luigi Mangione has not been indicted. Then the assignment of a district judge, that should happen first, and then the eventual notice of an intent to seek the death penalty. That all should have happened first. That's how it normally happens. First you indict, then you get a federal judge or a district judge appointed, and then you have a notice by the prosecution of their intent to seek the death penalty, and then you go through the process of saying, hey, should we or should we not? Is this the right thing to do? Let me talk about my mitigating factors. Let me talk about my aggravating factors. But instead, they bypassed all that. They have no indictment. They have no federal judge appointed, and they've already basically concluded death penalty is appropriate. All right. However, by then, a tainted ground jury may have already returned a true bill. Because the Attorney General's press release stated that she concluded the two statutory aggravating factors applied to the charged conduct, and that she said in her televised appearance that she was a capital crimes prosecutor and that there ever was a death penalty case, this is it, and because she said that she herself has been threatened because of her decision to seek the death penalty, there's a real chance that she has tainted this grand jury. No shit. Because most people think that your authorities are telling the truth. If your authority, if the leading authority in government, the Attorney General of the United States says, yeah, this is the definitive case of murder, and he clearly did it, and he needs to be prosecuted because if there's ever a case against anybody, this is the best one I've ever seen. A lot of people just believe it. They just believe it. It'll be a federal district court judge, which they haven't assigned, right? So that's a thing. Cynthia, that's my confusion. She's filing a motion here, which has to be ruled on by a judge, but no judge has been assigned to the case in the federal district, right? So are they just going to have a random judge, or are they going to now have to be, I'm curious now. Do they have to now appoint the judge who's going to oversee? Because they hadn't notified who the federal judge is going to be. Is this going to force them now to appoint the federal judge because that federal judge has to rule on it, or will it just be some random federal judge is going to rule on this, and then a different federal judge might be appointed to oversee the case? Super interesting question. Let me know, Rhonda, if Cynthia responds to that. All right. Did I read this paragraph on the screen? I don't think so. Also, because it is clear the Attorney General has made a final decision to seek the death penalty, even without providing counsel with the full opportunity to present mitigating circumstances, despite our request to do so, there is no meaningful opportunity at this point to change her mind. She has made it clear that her decision was driven by the administration's policy to make America safe again. Also, it is clear that she wanted this case to be the administration's first death penalty case. She issued the press release around her new Instagram account so that she could advise advertise her decision to seek the death sentence in this case, just like the other Attorney General had no interest in adhering to the process over the dismissal of Eric Adams' case or the illegal removal of Abrego Garcia. She has no interest in adhering to process in seeking the death sentence for Luigi Mangione. The record is clear.
Sophia wrote back.
Okay, hold on. Let me finish the sentence. The record is clear. The court does not need any more information than it has now to conclude the Attorney General's order to execute Mangione is arbitrary, political, and a breach of the established death penalty protocol. All right, they will assign one just to hear this. Okay, so the person who hears this may or may not become the judge that presides over the trial, and that's what I hear from you. Thank you, Cynthia, for that. This court does not have to wait for an indictment and a notice of intent to act. It should take action now and stop this corrupt process in its tracks. That's Karen's appeal. Stop this bullshit immediately. The United States Attorney General is our nation's highest law enforcement official. Her 3 public statements having significantly prejudiced this case, the New York State case, and the federal grand jury presentation. As for the press releases directing the Southern District of New York to seek the death penalty, there is no reason, aside from an improper one, to make the directive publicly. Like every attorney general making a death penalty decision before this one, she could have simply communicated this decision to the line prosecutors within the District Department and who would have then notified the defendant. In other words, the normal process is just to kind of do it behind the scenes and it gets notified by the defendant, but she decided to go not notify counsel, the defendant, and go immediately to the press to make the case to the public before the defense even found out about it. The defense found out about it from the press. That's how the defense found out about it, because the press saw the same press release everybody else did. But that was not enough. That was not enough for the Attorney General. Because she wanted to not merely tell the local prosecutors of her decision, she wanted to tell the world of her decision, including the grand jurors who will hear this case. She wanted the world and the grand jurors to know that her decision was rooted in the president's policy, specifically his agenda to stop violent crime and make America safe again. She called the murder an act of political violence. So this is some repetitive stuff. Even though Mr. Mangione is charged by complaint with stalking a single person, she signaled to the world and the grand jurors that she, the United States Attorney General, has concluded that the defendant violated 2 statutory aggravating factors, one of which she badly misstated. Because a grand jury would have to find these statutory factors present in order to vote on a true bill for a death-eligible offense, the Attorney General's prejudicial statements goes to the heart of what the grand jurors must decide. In other words, she's already telling the grand jury what they must decide because she's told them, yes, there are 2 aggravating factors here. Not you have to decide if there are. I've told you there are 2 aggravating factors here, so therefore you must go with the death penalty. As noted, the Attorney General also has never so much as suggested that Mangione was presumed innocent or that he was still not indicted for any federal crime. Page 27 of 33. Oh my gosh, we're almost there. We're going to make it before 9 Pacific Standard Time. That her real motive was press attention and not merely giving a directive to her line prosecutors is shown by what she did next. She timed the start of her Instagram account specifically around Mangione's press release. She ordered the death penalty and publicly released her order so that she would have content for her newly launched Instagram account. I'm an Instagram star. Again, her Instagram posting bear no indication that the defendant is presumed innocent. As the Attorney General, I've said over and over again, she should presume that he's innocent until proven guilty. The court simply cannot sit back and do nothing while a grand jury is convened, which has been exposed to this sort of malicious, intentional prejudice. Not in any case, much less a capital case. That's what Karen's argument is. The court can't stand by for this bullshit. You need to spank the U.S. Attorney General. She cannot do what she's doing, and a court needs to step up right now and uphold the law of the United States. Attorney General violated Local Rule 23.1. This is the one that they say that Pam Bondi should be forced to recite and certify that she knows this law. With respect to a grand jury or other pending investigation of any criminal matter, a lawyer participating in or associated with the investigation, including government lawyers, shall refrain from making any extrajudicial statements that a reasonable person would expect to be disseminated by means of public communication that goes beyond the public record or that is not necessary to inform the public that the investigation is underway, to describe the general scope of the investigation, or to obtain assistance in the apprehension of a suspect, to warn the public of any dangers, or otherwise to aid in the investigation if there is a substantial likelihood that the dissemination will interfere with a fair trial or otherwise prejudice the administration of justice. Holy shit! My English teacher would have hammered the piss out of me for such a huge run-on sentence. Did you see how many commas were in that thing? That was the longest run-on sentence I have ever seen in my entire... I was laughing during the thing because I'm like, when is this sentence going to end?
Are you paying attention to Cynthia?
No. She was following Trump directives. He will not fire her. Oh, I know Trump's not going to fire her. Trump's not going to fire her, yeah. But she's but Karen's asking the court to stop this bullshit, right? So that's the thing. She's not going to get fired. Or maybe Cynthia must have been responding to somebody in the text because I didn't say they were going to fire her. Oh. When the Attorney General issues a press release directing the Southern District of New York prosecutors to seek the death penalty, she knew they would do so by commencing a grand jury investigation. The Attorney General's public extrajudicial statements in the initial press release, in her Instagram post, and as part of the televised appearance prejudiced the very grand jury proceedings that she brought about. We're on page 28 and 33. Because the Attorney General is directing the grand jury investigation to be commenced, she is a lawyer, quote, participating in or associated with the investigation. In other words, she's directly violating this big, huge run-on sentence up here, where if you're participating in the investigation, and it says down here, she is clearly participating in the investigation. As such, she has an obligation to refrain from making any extrajudicial statement that a reasonable person would expect to be disseminated by this gigantic run-on sentence. I'm not going to read it again. It was super long. The Attorney General's three statements are extrajudicial statements. For the reasons set forth above, they are plainly prejudicial towards the administration of justice, which in this case involves a grand jury considering an indictment that can result in Luigi Mangione being executed. The recommendation of the Southern District of New York, as well as all memoranda provided to the capital case section or the Attorney General, would be relevant in the ultimate determination of whether the Attorney General's decision is arbitrary and political on the one hand, or principled and based on proper procedures on the other. Accordingly, we ask the court to direct the government to provide these materials to counsel. Continuing on with the complaint here, during her televised appearance, the Attorney General stated that a reason she ordered the death penalty was because the victim was a CEO. This raises the question of why the Attorney General would be motivated to seek the death penalty because the victim was a CEO, when the professional status of any homicide victim is plainly not a factor. We've read this before. It's a little repetitive. I probably should have left it. We're at the conclusion almost, but let's finish this paragraph. If the Justice Department was moved to seek the death sentence due to any communications by or on behalf of any corporate interest, this would be relevant to a finding that the death penalty was being applied in an arbitrary manner. Accordingly, the defense seeks all information that would tend to show that anyone on behalf of any business interest, like maybe the healthcare industry, communicated with the Department of Justice concerning the sentencing of Luigi Mangione. That's ultimately what I believe, reading through the Universal Translator, Karen's hinting at. Was anybody in the healthcare system, maybe United Healthcare perhaps, influencing the Department of Justice and how they proceed with Luigi Mangione? I want to know what business interests? What business interests? Healthcare system? CEOs of companies? Who is paying to have their word given to Pam Bondi to execute Luigi Mangione? Whose political interest and business interests are being met here?
And who's she doing some favors for?
Right. And that's it. We're not going to get into the appendix. We're not going to get into all the different, they outline a bunch of the different cases that the federal government has sought the death penalty and given examples to enumerate them ad nauseum in that attachment. We're done with the major part. 38 people at the end of the night, considering I don't think I've had 38 on YouTube at the middle of any night, is a record for me. Thank you so much. Please, please, please follow this account, even though I'm a long-winded bastard. Please also subscribe, follow, hit the notification bell so you can get notified when we go live again or when we put out new content. I am very, very busy doing a lot of work. Thank you, Cynthia, for staying with us and giving us some legal opinions. I am really sorry I didn't take the opportunity to bring you on. That was my bad. I got wrapped up in myself in my whole big long-winded spiel I had prepared for the night and was trying to rush through the content.
Being careful to walk on eggshells.
And being careful to walk on eggshells with TikTok. Hopefully everyone who stayed and heard the TikTok portion understands now in context why I'm implementing this new too hot for TikTok portion where I can't say this kind of stuff on TikTok. I don't think I would have been able to stay on TikTok if I had just repeated everything I just said for this last hour.
You would have been gone an hour ago.
All right, everybody, that's it. I'm done. I wish you well. Again, like, subscribe, notification bell, all that good stuff. See you next time.
Sarah,
Bye-bye.
if you're still here,
Yeah?
I don't know who won the bet. I almost sneezed, but it didn't. It didn't quite come out. So sorry, Sarah. Good night, everybody.
Good night. Good Lord.
Long night, huh?
6